Letitia George on behalf of the Office of the Public Defender.
All right. Good morning, sir. Please tell me your name.
James Royal.
I'm sorry?
James Royal.
Tin foil?
James Royal.
James. Royal. That's not right. All right, Mr. Royal, you're here in case number 21MM1716AO, charged with criminal mischief. I reviewed the probable cause affidavit, sir. There is probable cause in this case. I'll appoint the public defender's office to represent you. Your bond on this charge will be $500. Good luck, sir.
John Doe, Your Honor.
Yes.
He's a refusal.
All right, that's case number 21CT1930, 21CT1929. I'll find his refusal a willing waiver of his appearance today in court. Counselor, I'm going to appoint your office to represent him. There is probable cause. His bond will be $500 on count 1 and $100 on count 2. He can't drive without a valid driver's license.
Your Honor, I believe he has another case,
Here's another
a
one.
misdemeanor case.
Or resisting without.
Oh, there is, yes, you're correct. Thank you. 21MM1703. I also reviewed that probable cause affidavit. There is probable cause. I'll appoint the public defender's office, and his bond will be $500. Please tell me your name. This is case number 21MM1718AO. You're charged with criminal mischief. There is probable cause in this case. I'll appoint the public defender's office to represent you. Your bond is $500. You're not allowed to return to the scene or have contact with any witnesses in the case.
Your Honor, I believe she also qualifies for PTR, so I don't know if you want to do bond with PTR conditions.
I'm going to place you on pretrial release at this time. With special conditions, you're not allowed to return to the sugar factory or have any contact with any witnesses in the case. Do you understand?
Yes.
You're not allowed to possess or consume any alcohol or illegal substances, and you'll be subject to random alcohol and drug screens. Do you understand?
How long?
As long as you're on pretrial release.
Okay, how long is that?
Sorry.
That depends on how long it takes to resolve the case. So you can't drink alcohol and you can't take any drugs. Do you understand?
Yes.
All right, good luck. Please tell me your name.
Ashana Smith.
You're here in case number 21MM171780, charged with trespass on property after warning. I'm going to appoint the public defender's office to represent you. There is probable cause.
What's her name? Who's this?
The state have an offer.
Yes, Your Honor, an adjudication credit time served.
Your Honor, we would ask for an ROR in this case. On January 11th, 2021, she was found incompetent.
Oh. Does the state have any objection to an ROR?
No, Your Honor, not if she's been previously found incompetent.
All right, at this time, I'm going to release you on your own recognizance. I'll order that you have to stay in touch with your attorney, that you're not allowed to return to the Citgo gas station. Do you understand?
Yes, ma'am.
All right, and that you comply with any orders from a doctor. Good luck.
All right, really.
And I'll take no action on the out on bond case.
All right.
Please tell me your name.
Ashika Lovey Blackman.
In case number 2013 CO 90680, a capias was issued for your arrest for failing to appear for arraignment back in 2013 on a charge of possession of alcohol in public. The bond on that is $2,000. Does the state have an offer?
Yes, Your Honor. A withhold, the court costs, and the $10 filing fee.
Are you interested in accepting that?
I didn't hear what she said.
A withhold of adjudication, credit time served, court costs, and a $10 filing fee.
$10 fine, court cost?
Yes, ma'am.
Okay, what's court cost? Okay, yeah.
Around $300.
$300?
It's around $300. I can't waive the court costs, so I have to order that you pay them, whether you enter a plea today or at a later time.
Okay, oh, so I have time to pay that.
Oh, yes, I'll give you a year to pay it.
Okay, thank you, yeah, I accept that.
All right, did you have a chance to talk to the public defender about this?
No, she was separated, Your Honor.
She just asked me a couple of questions, but I didn't talk about my case.
All right, did you explain to her the rights she's giving up if she enters a plea?
No, I wasn't able to see her. She was in chains. She was in a different cell than the other women, Your Honor.
Y'all, it's 11. We had plenty of time to do this morning.
Your Honor, I normally don't see the ones in chains. They're separated in a different cell. I only see the group.
Ma'am, raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Do?
Thank you. You understand that if you enter a plea of guilty or no contest today, you'll be giving up certain rights, like your right to remain silent, your right to testify at a trial where one is required, your right to call witnesses and present any defenses you may have, your right to require the state of Florida to prove the charges against you beyond all reasonable doubt. If you enter a plea of guilty or no contest today, you're going to give up those rights. You understand that?
Yes.
You understand if you're on probation, this plea could violate that probation.
So I'm not on probation.
All right. I'm not saying that you are.
Oh,
I just have to advise you that if you are, this plea could violate that probation.
Okay.
You understand if you're not a United States citizen, this plea could subject you to deportation.
Yes.
All right, at this time, how do you wish to plead to the charge of open container of alcohol in a public place?
It's been so long ago, I don't even remember. And I've been lived here since 2013.
I understand that, and ma'am, you don't have to enter a plea of guilty or no contest today. If you want to talk to an attorney about this, you might have some defenses. Your attorney might be able to get the state of Florida to drop the charges altogether. I don't know. But you don't have to enter a plea of guilty or no contest today. You can enter a plea of not guilty. I'll appoint the public defender's office to represent you, and then you can talk to them about any defenses you have. So you can do either of those things.
I'll just plead guilty, 'cause I don't go through.
All right, you understand if you enter a plea of guilty, I'm going to sentence you today.
Yeah,
Is that what you want?
she said time served?
Right.
Okay,
That is what I'll sentence you to. All
okay.
right, has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
All right, at this time, I'll accept your plea of guilty. I will withhold adjudication, give you credit for 2 days in jail. I have to order that you pay court costs. I'll give you a year to pay them, and also the $10 filing fee, and I'll give you a year to pay that as well.
Thank you.
Yes, ma'am, good luck. Please tell me your name.
Harvey Michael Dudley.
In case number 20 CF 1383780, you're charged with battery on a law enforcement officer, resisting an officer with violence, and criminal mischief. I'm going to appoint the public defender's office to represent you. I reviewed the probable cause affidavit. There is probable cause in this case. Hold on one moment, sir.
Well, I don't know, Your Honor. My parents are police officers, man. These guys are out of hand, man. Yeah. The police officers and, yeah, my mom and dad are in Tallahassee. And your
Okay.
boys are out of hand. Yeah. They can put their hands on me illegally. And I don't think it takes so much as a human. Yeah, this charge comes
There's
out,
some competency
this charge comes out of
concerns
1994.
in this case, Your Honor.
Yeah, it comes out of 1994. I can't get it off my record, so.
So in this case, sir, the allegation is that this occurred in November of last year. But what I'm going to do is appoint the public defender's office to represent you, so you have a lawyer that you can talk to.
Yes, ma'am.
I'm going to make your bond $1,000 on count 1, $150 on count 2, and $100 on count 3. Make sure you stay in touch with your attorney, all right, sir?
Yes, ma'am.
And you're not allowed to possess any weapons or a gun.
Yes, ma'am.
All right, good luck, sir.
Any action on the out of bond, Your Honor?
No.
It's the same case number, that's all.
Right. That's why I'm not. I think it has to do with what the state charged. Please tell me your name.
Reagan Younger.
In case number 21CF2880, you're here for possession of methamphetamine. There is probable cause. I'm going to appoint the public defender's office to represent you.
I have a judge. I'm sorry, I have an attorney.
You have an
I
attorney?
am an attorney, and I have an attorney, David Webster. I haven't been able to make a phone call, so.
All right. So then you don't want me to appoint the public defender's office?
I'm uncertain, but I believe not.
So if you can hire an attorney, and you have hired an attorney, you don't need the public defender's office to represent you.
Okay, then no. Is that the only charge?
I'm sorry?
There's only one charge?
No, I'm not done yet.
Oh, okay.
So on that charge, your bond is $1,000. You're not allowed to possess or consume any illegal substances, and you're not allowed to have contact with any known drug dealers. In case number 21CF2571AO, a capias was issued for your arrest for first-degree murder and possession of methamphetamine. There is no bond authorized on that. And again, you don't want me to appoint the public defender's office because you have an attorney?
Right.
Is that correct?
That's correct.
All right. As to case number 20CF13441AO, I'm going to revoke your bond. So you'll want to tell your attorney that the judge revoked your bond on that case as well. Good luck.
You said that no bond on both,
Yes.
the first degree and the possession of it.
Yes. So next, I have Joseph Martin. Yes. Okay. Morning. Please tell me your name.
Joseph Martin.
20MM298AO. Counselor, if you want to put your appearance on the record, please.
Jason Bengals, we have Mr. Martin, Your Honor.
All right, so you're here for a violation of domestic violence injunction charge to be arraigned on that charge.
It's on a violation of probation for that charge, Judge.
I think you're right, it's a VOP. All right, this is a Division 50 case. What's the next court date for Division 50?
The trial conference will be April 15th at 2 p.m. courtroom 7, private attorney, I'm sorry. 9 a.m. courtroom 7C.
So it's 9 a.m. that day.
Thank you, Judge. We'll get it figured out. We, I think we're in the process of scheduling a bond hearing for him anyway, so.
All right,
We were hoping that potentially we could work it out, but I understand the state's stance that they don't want to touch it without victim contact or anything at this point due to the nature of the violation.
right, I understand. All right,
Thank
thank
you,
you. Anything further, Counselor?
That's all that I have. May I be
Thank you, sir.
excused?
Have a nice day. Good
If I
luck,
can
sir.
Figure out how to get out of here. Can I be excused?
Yes, once you figure it out. Spanish interpreter cases?
Yes, ma'am.
Work.
Good morning. This is Dalia Romero, Spanish interpreter on the line, already sworn in today. Allow me to connect to the podium, Your Honor.
Yes, please, thank you.
Thank you. He can hear the interpreter.
Please tell me your name.
Jonathan Manuel Reyes Sánchez. Manuel Reyes Sánchez.
Jonathan Manuel Roger Sanchez. And Manuel.
A warrant was issued for your arrest in case number 21 CF 1438AO, charging you with burglary of a dwelling with assault or battery, grand theft, and battery dating violence. That means another judge has already found probable cause. Let me ask, ma'am, do you wish to testify? And do you need the services of, can you ask if the victim needs the services of?
I know English.
Or the witness? Oh, you don't need?
No, I'm
Okay.
fine.
Do you wish to testify?
Yeah.
All right, please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Kaylani Chacon.
State you may inquire.
Good morning. Can you please state your relationship to the defendant?
He's my boyfriend.
And are you afraid of him?
No.
If he were to get out of jail today, would you be afraid of him?
No.
Were drugs or alcohol, did they play any part in this event?
No.
And has anything like this or any other violence between you two ever happened before?
No.
And if anything were to ever happen in the future, would you be willing to call 911?
Yes.
That's all I have at this time, Your Honor.
I'm going to appoint the public defender's office. Does the defense wish to inquire?
No, Your Honor.
All right, thank you. Sir, you have no bond on count 1. Your bond is $1,000 on count 2. And it'll be $100 on count 3. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Wait, can I?
Just a moment. Do you understand?
Yes.
Yes, ma'am. Do you have a question?
We're together. Like, we're together.
At this time, he's not allowed to have any contact with you, and he's not allowed to return to your residence. So at this time, you can't have any contact. Well, he can't have any with you. You understand you can't have electronic communication, telephone, or communication using a third party like a friend or a family member.
Yes.
You're not allowed to return to the scene. You're not allowed to possess a weapon of any kind, firearm or ammunition.
I don't need to see our court. I can just.
Are there any other conditions the state would request?
No, Your Honor.
Were you living at this residence?
Llegué a vivir una vez ahí. Llegué a vivir una vez ahí un mes.
I lived there once for a month.
All right, so you don't have belongings at this residence?
No.
All right.
Me mudé hace poco. A la Cinia, 244 Cinia Drive.
I moved to 144 Senior Drive.
All right, so you can't return to her residence for any reason at this time. Good luck, sir. Thank you, ma'am, for coming.
I don't get to say nothing.
If I could, remind me, please. Please tell me your name.
He's already called.
I know. They're bringing it back up. Gabriel Rodriguez.
Gabriel Rodriguez Rodriguez.
I don't know if it's.
You're here in case number 21CF 2889AO, charged with lewd or lascivious battery and sexual act with a 16 or 17-year-old child. There is probable cause. I reviewed the probable cause affidavit. I'll appoint the Public Defender's Office to represent you. Can counsel advise what level felony is count 1
I believe it's second-degree felony, Your Honor.
and count 2 as well?
Yes, Your Honor.
All right.
Due to the age of the child.
That's what I thought. I just suddenly thought I should double check that before I.
I double-checked it as well.
Thank you. Your bond will be $100,000 on count 1, $100,000 on count 2. You're not allowed to have any contact with the victim or the victim's family members. You're not allowed to return to the scene for any reason at all. You're not allowed to have any unsupervised contact with any minors under the age of 18. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Good luck. Please tell me your name.
Daniel Kalke.
Daniel Kalkeker.
In case number 21CF 2890AO, you're here charged with aggravated child abuse. I reviewed the probable cause affidavit.
Discúlpame, ¿puedo repetir otra vez? No lo entendí muy bien.
I'm sorry, can you repeat that again? I didn't understand that very well.
You're charged with aggravated child abuse. I reviewed the probable cause affidavit. I'm going to appoint the Public Defender's Office to represent you.
Sorry, Your Honor. May the interpreter inquire from the defendant?
Yes, please.
Hablo, sí, alguna lecto, quechua.
Your Honor, this defendant speaks a dialect, which is Quechua.
All right. Does that mean he doesn't understand you?
We've experienced this in the past. It's not Spanish, so he's probably not understanding what the charges are.
So are we able to get an interpreter who he could understand?
You could you could connect with Language Line, and they should have an interpreter in his language.
All right, what we'll do, can we pass him and let's see if we can figure that out?
Yes. Señor, one moment. Señor,
Quechua.
he speaks a language called Quechua.
All right,
And I,
pass him and we'll see if we can get an interpreter for him.
Okay, gracias.
okay, thank you.
Thank you.
And that case number was 21 CF, I'm sorry, Your Honor, 29?
2890.
Thank you.
Okay. Please tell me your name.
Luis Enrique Sane.
Luis Enrique Santana.
No, Luis Enrique Sane.
Luis Enrique Sane.
Yes.
In case number 2019 CF 13966, a warrant was issued for your arrest for violating your probation in that you left your county of residence without first getting the consent of your probation officer, and you failed to remain confined to your approved residence except for 1/2 hour before and after approved employment, public service work, or other special activities. There is no bond authorized on this warrant, and I will appoint the Public Defender's Office to represent you. Good luck, sir. Yes.
Can I ask a question?
Yes.
Sí. ¿Puedo hacer una pregunta? Porque yo mañana terminaba el Community Control y yo hice todos los programas, no le debo chavo a la corte, todo lo que me mandaron a hacer ya yo lo hice. Y yo quería ver si me podían dar time served, tiempo cumplido.
Tomorrow I finish with everything with my community control. I don't owe any money. I've done everything that they ask of me. I wanted to know if I could get credit for time served.
Not today. Another judge issued that warrant for your arrest. They signed it and said no bond for those failures on probation. So you'll have to talk to your attorney about your defense, but the allegation is that you violated your probation. We will not have that hearing today. It's in front of the trial judge. Yes, sir.
Yo no fue del trabajo, yo en mi casa, porque yo no trabajo. Fue en mi casa que yo salí a rescatar a mi hija que se quedó a pie con sus niñas.
I don't work. It was from my house. I am not employed. I had to leave to rescue my daughter who was stranded with the children.
I understand that could be a defense to the charge of violating your probation, but you'll have to raise that in front of the trial judge. So talk to your attorney about that. Yes, sir.
Okay. ¿Cuándo yo puedo hablar con mi abogado, con el public defender?
So when can I speak to the public defender?
That's between you and the public defender. They know they've been appointed. I just appointed them and she's sitting in the room, so she'll make sure that her office knows that they're appointed.
Una última pregunta, y perdón.
One last question, and I'm sorry.
It's okay.
¿Y hasta cuándo yo tengo que estar aquí en la cárcel?
How long would I have to be in here in the jail?
That's up to the trial judge. Right now, you have no bond. So your attorney will have to file a bond motion in front of the trial judge.
Gracias.
Thank you.
Good luck, sir. Your case?
No, actually, I didn't see him up there.
Please tell me your name.
Candy M. Tanco Morales. Tanco Morales.
Candy M. Morales.
You're here because a warrant was issued for your arrest out of Osceola County in case number 20MM1040 for failing to appear. There is no bond authorized on that warrant, and I will appoint the Public Defender's Office to represent you, and will tell Osceola County that you're here.
Okay.
Good luck. Hold on one moment. Do we have any more Spanish speakers?
One more.
All right.
Leon Angel, felony domestic. Does she need an interpreter?
Ma'am, do you speak English?
Yes.
All right, so she doesn't. Sir, please tell me your name.
Ángel Milian. Sí.
Angel Milian.
Case number 21 CF 288780, tampering with a witness and battery domestic violence. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. Ma'am, do you wish to testify?
Yes.
Please raise your right hand to be sworn.
Please swear to tell the truth, whole truth, and nothing but the truth, so help you God. Please state your name for the record and spell your last name.
Natalie Figueroa, Figueroa.
State you may inquire.
Good morning, ma'am. Can you please state your relationship to the defendant?
He was my boyfriend and my son's father.
Okay, and how long was he your boyfriend?
For about a year.
Okay, and are you afraid of him?
I would like to state that I don't want to have contact with him, but I want to see what is available for him to have supervised visits with my son, but I don't want him near me.
Okay, so I appreciate you telling the court that, but back to the question I asked you, are you afraid of him?
Yes.
Did drugs or alcohol play an event?
No.
Has anything like this ever happened before?
No.
And are you willing to call 911 if anything like this were to ever occur in the future?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Thank you, ma'am. All right, sir, your bond will be $1,500 on count 1, $100 on count 2. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Okay.
You can't call her, you can't talk to her on social media, you can't send a message through a friend or a family member. No contact at all. You understand? You're not allowed to possess a weapon of any kind, firearm or ammunition, and I'll order that you must maintain a separate residence. Sir, do you live here in Florida?
Sí, yo vivo en la Florida.
Yes, I live in Florida.
All right. I'm also going to order that you're not allowed to possess or consume any illegal substances, and you'll be subject to random drug screens.
May I ask a question, Your Honor?
Yes.
How would I go about, or what would I do for him to be able to see the baby?
At this time, he can't talk to you or a family member to get to you.
And then
So what
when
will happen
would-
is you'll be in contact with the state attorney's office. That's who's bringing these charges.
Okay.
And then they can work out with his attorney when he can have contact with you once a judge approves it. But until a judge says he can have any contact, he cannot.
Okay.
So I'm going to order that you maintain a separate residence. So you're not allowed to live with her or go to her residence for any reason. Do you understand? Not even for your son at this time. All right, good luck, sir. Thank you, ma'am.
Thank you.
I think that's the last of the interpreter cases. Thank you for your time and service this morning.
You're welcome, Your Honor. Thank you.
Okay, what is this? I'm sorry. Oh, we have an interpreter. Oh. How do I get them? Teleconference? Hello? This is Judge Gibson. Can you hear me?
Yeah, this is Romeo's interpreter. Check.
So I don't know if he can connect to the headset. All right, so it's just over the loudspeaker? All right. Has the interpreter been sworn?
No.
Please raise your right hand to be sworn.
Do you swear to translate from?
Okay.
You gotta get to the mic.
Do you swear to translate from Catchy to English, English to Catchy, the testimony that we will receive today?
Yes. I just want to make sure that it's Piche na
Kekchi.
Okay, well, whatever the pronunciation is.
Okay.
All right, thank you. Please tell me your name, sir.
Romeo Sosa.
No, I'm sorry. I'm asking if you can ask him to please tell me his name.
Okay. Kuyaka Bihlabi Khaslabi.
Do you understand the interpreter, sir? No. He doesn't understand you.
Yeah, I believe. ¿Qué idioma hablas? Quiche, Kekchi?
Kekchi.
Yeah, that's a different language. It's not the language I speak. I speak Quiche.
All right, we'll try this again. Thank you.
You're welcome. Bye.
All right, let's try one more time, but let's keep going. Well, that didn't work out. Please tell me your name.
Erin Hollock.
This is case number 21 CF 2817AO. You're charged with neglect of a child, possession of drug paraphernalia, and possession of cannabis under 20 grams.
Yes, ma'am.
I'll appoint the public defender's office to represent you. Did you have additional information from the state attorney's office?
No, Your Honor, just argument.
I'm sorry, what?
Just argument. Judge Bain yesterday found PC to the paraphernalia and the cannabis and reset it just as to the neglect. But I do not have any more information at this time.
But do you have argument?
Yes, Your Honor.
I'll hear it at this time. Get close to the microphone, please.
Sorry.
Sorry, it's really hard to hear you.
According to the affidavit, there are 4 things that I think point to the neglect of a child PC that are needed for this case. First, the vehicle containing the child and the defendant pulled into a quick stop. An unknown male approached the vehicle, spoke to the occupant, and then the vehicle pulled away and ultimately committed a traffic infraction. Arguably at midnight at a quick stop, that could be determined to be a drug deal since drugs were later found in the vehicle. Second, the officer notes a strong pungent odor of cannabis, and the defendant admitted to smoking in the vehicle. Upon pulling over the vehicle, the officer describes it smelled of a strong pungent odor of burnt cannabis. And when the officer told the defendant what he smelled, the defendant stated that they smoked cannabis and there was cannabis in her purse. The child was in that vehicle with the air. Third, there's a jar of suspected cocaine under the driver's seat, a jar of suspected mushrooms in the defendant's purse, and cannabis within the defendant's purse. The jar of the suspected cocaine was reported to be within 2 feet of the child who was laying down in the back seat. And the jar of cocaine was under the driver's seat, so about 2 feet from the child. And then lastly, the child was laying in the back seat under clothes and a blanket. Law enforcement didn't even observe the child until they already took all the occupants out and they started a search of the vehicle. The child was unsecured, laying down, and with no seatbelt or car seat. And again, it was approximately midnight, and they are driving on rather populated roads here in Orange County. The conditions of the vehicle put that the child was susceptible to put the child at risk. Under neglect of a child, the state would have to prove that the defendant willfully or by culpable negligence failed to provide the appropriate care, supervision, or services to maintain the child's physical or mental health. Citing those 3 or 4 things, the state would argue that she did not provide the appropriate care or supervision that would ultimately hurt the child's physical or mental health. Being around the odor of cannabis that the officer described as strong and within reach of 2 feet of the suspected cocaine that did field test positive for cocaine. And the defendant also acted willfully by creating the situation and permitting the suspect conditions to exist around her child. That's all I have.
Defense have any argument?
Your Honor, my only argument would be Yesterday, this was brought up. Judge Bain had already found no PC. The state was supposed to get additional information in order to find PC, which they did not. The only thing we have is the same arrest affidavit where Judge Bain already stated there was no PC. So at this time, because the state doesn't have any other additional information, we would ask for an ROR on the neglect of a child, finding there is no PC.
So, Counselor, I think there is PC. In reading the probable cause affidavit, I found probable cause. Then I got a phone call from Judge Bain, and he told me that this case was coming back from yesterday, but I believe there is probable cause.
Okay, Your Honor, if you believe there is probable cause, but we would argue there is no probable cause. The smell of cannabis in a car is not neglect of a child. There's no proof that she was smoking any type of drugs in the vehicle with the child. And although the child was not in the proper seatbelt, that is a traffic infraction.
So the pungent odor of burnt cannabis isn't enough to suggest that she was smoking in the car? How would the odor get in the car then?
There was also an admission that they smoked in the vehicle.
She stated she smoked in the vehicle?
However,
It just stated that they smoked in the vehicle, not whether or not the child was present.
in the
but There was
vehicle.
an admission that they did smoke inside the vehicle.
All right, so let's look at the statute. Neglect of a child means a caregiver's failure or omission to provide a child with the care, supervision, and services necessary to maintain the child's physical and mental health, including, but not limited to, food, nutrition, clothing, shelter, supervision, medicine, and medical services that a prudent person would consider essential for the well-being of a child, or a caregiver's failure to make a reasonable effort to protect the child from abuse, neglect, or exploitation by another person.
Your Honor, and again, I will point out that the judge has only allowed 24 hours for the state to file additional supplemental information. He found no PC. He gave them 24 hours to provide additional information. No additional information was found. Therefore, we would ask for an ROR on the neglect of a child and no PC. That was already determined yesterday.
So I think you're going to have to bring this back to Judge Bain tomorrow.
Okay, Your Honor.
Because I read the affidavit, I find probable cause, I read the statute, I think there's probable cause in this case. So I can't make a finding that there is not probable cause for neglect of a child. However, if you're arguing that Judge Bain already found there is not, then I think Judge Bain has to do that.
But then we would hold her. Okay. We would ask that it be brought back up in front of Judge Bain.
So it's reset tomorrow?
Let me think this through. I'm not going to authorize a release on her own recognizance. I think there's probable cause. I can't do that.
And she still has a bond. She can bond at any time.
Does, but we would ask that it be set back before Judge Bain. Your Honor.
Oh, that's right. She does have a bond on that.
She does have a bond.
Right. Yeah, so she won't be held on it. I'm not revoking that. There is still bond.
Yes, Your Honor. However, we would just ask that it be set back before Judge Bain tomorrow.
All right, you can do that. Good luck, ma'am. Did he put any conditions on that bond?
Not at that time, Your Honor.
Come back for one moment. Because the bond is still in place, at this time, I'm ordering that you're not allowed to have any unsupervised contact with your child and that you must maintain any plan or order by DCF. So if you are able to bond out and you do bond out tonight, you can't have unsupervised contact with the child. You're not allowed to possess or consume any illegal substances, and you'll be subject to random screens. Do you understand?
Yes, ma'am.
And you're not allowed to have any contact with any known drug dealers.
Yes, ma'am.
Good luck.
And actually, that's we don't need to recall her. I just was hoping I could I'm Dave Webster. I was hoping I get a copy of the probable cause affidavit or the arrest warrant or something that I could take a look at.
You have to get that from the state of Florida, right? Did you file a notice of appearance and a demand for discovery?
I have not filed anything yet. So I just was hoping that I could look at the probable cause affidavit that was addressed this morning, but that's fine.
So I don't have a probable cause affidavit for the murder charge, if that's what you're asking about. I have a capias,
Okay.
so I can't.
And there's no packet on the warrant or anything?
No, I don't have a warrant and I don't have an affidavit. I just have a capias, that's all.
Perfect. All right. That's all
It
I
was
need.
charged that way.
Perfect. And I didn't mean to bring her back up. I just was hoping maybe I could.
Oh, sorry if I
No,
don't
no.
have anything.
No, that's okay. I appreciate your time.
Absolutely. Good luck.
Okay, thanks.
Thank you, sir.
You couldn't even see it. Okay.
Yeah, we don't have it. Oh, you're kidding. Well, that's interesting. All right, so let's bring him back in here. You have his paperwork? Oh, okay, let's do him and then we'll bring him back. Sir, please tell me your name.
Lyndon Brown.
In case number 20 CF 1476680, a capias was issued for your arrest for battery with one prior battery. There's no bond authorized on that capias. The public defender's already been appointed. You're not allowed to have any contact with the victim. You're not allowed to possess a weapon of any kind, firearm, or ammunition.
He has, he has a.
What says the state as to his out on bond case?
Are you, the out of bond case, are you referring to the other battery one prior?
No. Is he out on bond on that? I have that he's out on bond on a fleeing and attempting to elude, possession of controlled substance, and Dwillis as a habitual offender.
They got taken care of
Yeah.
yesterday.
I don't have.
Okay, so that's not out on bond?
No, I'm not out on bond on none of that. They got
Well,
taken care of yesterday, man.
He was actually out on bond, Your Honor, but I guess he's seen the judge on the case, and they time served him on that yesterday.
All right, then I'll take no action on that. Good luck, sir.
I have
Yeah.
two battery one priors. One with a victim Dawson and one with a victim Harmon.
Hold on, what is the case number of the other one then?
All I have is in a rare, the agency case number.
20 CF 12873?
No, that's one I have with the battery one prior domestic violence with a victim Dawson. Also have a battery.
That's the capias. I already addressed 20 CF 14766. That's the capias with no bond. So the warrant is 20 CF 12873?
Yes, Your Honor.
All right, a warrant was issued for your arrest. I'll appoint the public defender's office to represent you. The paperwork is all confused. Hold on a second. That information has already been filed by the state attorney's office. Your bond will be $1,000. You're not allowed to have any contact with the victim. You're not allowed to return to the scene. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck, sir.
That's on both charges, ma'am?
No, on one you have no bond, on the other your bond is $1,000. But on both charges, you're not allowed to contact the victim, and you're not allowed to possess a weapon or firearm or ammunition.
Okay.
Good luck.
Sorry, Your Honor, for the confusion.
Yeah, the paperwork was,
It's fine.
like, the cases were split, so it looked like one case to me. Do you have this, defendant? Is it this one?
Oh, yes.
All right, we're back to Daniel Kalkick, 21 CF 2890AO. Sir, do you understand any English?
No, español sí lo entiendo muy bien.
Did he say Espanol?
Sí.
So it's better for him in Spanish? All right, hold on a second.
Good morning, Your Honor. I apologize. The interpreter should be available in the next 5 minutes. I apologize. All 5 of the interpreters are in trial, and the one interpreter is just taking a quick break, and she should be back at her desk in 5 minutes.
Okay. All right, we'll call back then. Thank you.
Okay. Thank you, Your Honor.
Once more. Please tell me your name.
Edmund Hayes.
In case number 21 CF 1089AO, a warrant was issued for your arrest for robbery by sudden snatching and battery domestic violence. That means another judge has already found probable cause. I'll appoint the public defender's office to represent you. Ma'am, do you wish to testify?
Yes.
Please swear in.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help your name? So help you God?
Omari Jones.
I'm sorry.
Omari Jones.
Could you spell your last name, please?
Jones.
State you may inquire.
Good morning, Ms. Jones. Can you please state your relationship to the defendant?
That's my boyfriend and my child's father.
And how long have you known him?
For about 3 to 4 years.
And are you afraid of him?
No, not at all.
Were drugs or alcohol involved in this altercation?
No, not at all.
Has anything like this ever happened before between the two of you?
No.
And are you willing to call 911 if anything were to occur in the future?
Yes.
And lastly, if he were to get out today, would you want to have contact with him?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Thank you, ma'am.
I have something to say.
Yes, ma'am.
I just feel like it was a whole misunderstanding. I reached out to the state of attorney office to drop the charges, but I'm not sure what is this about. Like this, I feel as if the charges are extreme.
So, ma'am, you can talk to the state attorney's office about that. They're the ones who are bringing the charges.
Okay.
At this time, a warrant was issued for your arrest, so there's already been probable cause found.
Can I speak?
You can, but everything you're saying is being recorded and can be used against you later.
Okay.
Is there anything you want to say?
How is what's up?
Is that a no? All right.
I'm not used to this, so I don't know what I can and can't say.
You can say anything you want, but everything you're saying is being recorded and can be used against you later.
Okay.
So that's why your attorney has advised you, I'm sure, to say very little. He qualifies for pretrial release. Does the state object?
No, Your Honor, I gave you an updated copy. I don't know why they qualified, because robbery is on the admin order.
I thought it was.
Yeah, it's
I
not
couldn't.
being qualified.
And can I speak?
You can.
Okay, and I don't understand why it's even a robbery charge. I even, said something to the officer about that as well, because we share everything, like literally when it comes down to my phone, everything, we share everything. So what's his is mine. So robbery is how can someone rob from me?
So in the affidavit states that he snatched the phone from your hands, shoved you to the ground, and said you would not be getting the phone back.
Okay,
So at that
yes.
time, let me talk. At that time, what you reported to the police was not that you share everything.
Okay.
He said he'd not be giving you your phone back, and the phone cost $1,000.
Okay.
That's the robbery.
Okay, so in this case, I got my phone back, so.
It doesn't matter. The robbery's already occurred.
Okay.
We're not going to try the case today.
Okay.
Your bond is $5,000 on count 1, $100 on count 2. I'm going to order that you're allowed to have peaceful contact with the victim. Do you understand what peaceful means?
Yes, ma'am.
You can't even raise your voice. You can't put your hands on her. You can't snatch her phone out of her hands. You understand?
Yes, ma'am.
I'm going to order that you maintain a separate residence. Were you living together?
Yes.
Yes, ma'am. We live together.
You don't right now. I'm going to order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You're not allowed to possess a weapon of any kind, firearm, or ammunition.
Your Honor, we would ask that they live together. He's in prison full-time, never had a criminal history at this time. This isn't a situation where it's like a really violent offense, and because of that, we would ask that you allow them to remain to live together. And she stated that she feels okay to call the police if anything happens. In addition to that, Your Honor, we would just ask that you lower the $5,000 bond. My client does have zero criminal history at this time. And I know the charge doesn't qualify for pretrial release, so we would just ask that you take that into consideration.
I'll consider lowering the bond to $2,500, but I'm not going to allow them to live together. So you're allowed one-time return with law enforcement to gather your belongings. That's it. But you can have contact. I've ordered peaceful contact. So you're still allowed to talk to her, but you can't live at that residence. All right, good luck. Thank you, ma'am. Yes?
Can I allow him to stay because I
No.
can go home?
You cannot do that right now.
Okay.
That violates the court's order, and he can be arrested for that.
Okay.
All right, good luck. Thank you for coming. Good luck, sir.
The plan is a behavior, Your Honor.
21 CF 288180, aggravated battery with a deadly weapon, domestic. There is probable cause. I'll appoint the public defender's office to represent him.
We'll waive, Your Honor.
Bond will be $5,000, and I'm placing him on pretrial release. No contact with the victim, maintain separate residence, no weapons, firearm, or ammunition. Maintain separate residence, one-time return with law enforcement to gather belongings. Please tell me your name.
Shamika McFadden.
Case number 21 CF 284980. You're charged with attempted first-degree murder with a firearm, aggravated assault with a deadly weapon, possession of a controlled substance, possession of methamphetamine with a weapon. I'm going to appoint the public defender's office to represent you. There is probable cause in this case. You'll have no bond on count 1, $5,000 bond on count 2, $150 on count 3, and $5,000 on count 4. You're not allowed to have any contact with the victim. Do you understand what no contact means? Ma'am?
Ma'am?
Do you understand what no contact means?
Yes, I do.
You can't call him on the phone,
I wasn't.
send a message through friends, contact anyone using social media. Ma'am, I need you to listen. Do you hear what I'm saying to you?
Ma'am.
No contact. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to possess or consume any illegal substances, and you're not allowed to have contact with any known drug dealers. You're not allowed to return to this scene for any reason. Are there any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am.
Yes.
No contact.
Please tell me your name.
Alfonso Moore.
In 21 CF 288880, you're here charged with battery, domestic violence, and child abuse. I reviewed the probable cause affidavit. There is probable cause. I'll appoint the public defender's office to represent you. On count 1, your bond will be $100. On count 2, your bond is $1,000. You're not allowed to have any contact with the victim. Do you understand what no contact means?
Yes.
You can't call her on the phone. You can't send a message through friends. You can't contact her on social media. Do you understand?
Yes.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to the target at 4750 Millennia Plaza Way. You're not allowed to have contact with any witness in the case. I'll order that you must maintain a separate residence. You're allowed a one-time return with law enforcement if you need to gather belongings. You're not allowed to have any unsupervised contact with the minor child. Do you have any other children?
Yes.
You're not allowed to have any unsupervised contact with any minor children. Do you understand?
Yes.
I'll also order that you comply with any plan by DCF if there is one. Good luck. Please tell me your name.
Evan Washington.
21 CF 2876. You're here charged with tampering with a witness and battery domestic violence. I'm going to appoint the Public Defender's Office to represent you. I reviewed the probable cause affidavit, and I do find probable cause exists in this case. This doesn't qualify for pretrial release?
It does, Your Honor. They just had some concerns because he's from out of state, and we didn't have anyone to talk to verify, or we didn't speak with the victim, so we weren't too sure.
Do you live in Florida?
No,
Where do you live?
I live in Michigan.
All right, your bond will be $2,000 on count one, $100 on count two. You're not allowed to have any contact with the victim. I'm sorry? You understand what no contact means?
Yes, ma'am.
You're not allowed to, I'll order that you maintain a separate residence. You're not allowed to return to SeaWorld. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Are there any other conditions the state would request?
No, Your Honor.
Good luck.
Hello, how are you doing?
Good. Please tell me your name.
My name is Brandon Wise.
In case number 21 CF 2800, a warrant was issued for your arrest for aggravated assault, battery, domestic violence, and stalking. That means the judge has already found probable cause. I'll appoint the Public Defender's Office to represent you. Ma'am, do you wish to testify?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record.
Catherine Evans,
Could you spell your last name, please?
EVANS.
State may inquire.
Good morning. Good morning. And what is your relationship to the defendant?
He's my boyfriend.
And how long have you been
Sir,
dating?
look at me. Go ahead.
Like 8 months.
Are you afraid of him?
Not really.
Oh,
I'm sorry, I couldn't hear that. What?
No.
If he were to get out of jail today, would you be afraid for your safety?
No, like him, can I say something else? Me and his family believe he has some mental health issues. He's never done this before. He's going through depression, like had suicidal stuff and everything. So we want him to go and get mental health.
Look at me, sir.
Evaluation and get help for that. Okay. And that's why he's acting. This situation happened, and he didn't stalk me at all. So I don't know whether that's a charge, and he didn't assault me with a weapon.
Okay, so back to kind of what I asked you, since you mentioned all of that potential mental health issues, if you were to get out, would you be afraid?
No.
And were drugs or alcohol involved in this altercation?
I don't know.
Has anything like this ever happened before?
No.
And if anything like this were to ever happen again, would you be willing to call 911?
Yes.
And if he were to get out, would you want to have contact with him?
Not until he's done with his mental health situation.
Okay, that's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
Does the defense wish to be heard on anything?
We would just ask for to see if he could get screened for mental health pretrial release. I'm not sure he will, but in the alternative pretrial release, the victim just testified he needs to get some mental health, his mental health together, and because of that, Your Honor, he's employed full-time, no criminal history, no convictions. We would just ask for pretrial release in this case.
I'll order that if he qualifies for mental health pretrial release, can he be screened for that? All right, otherwise, I'll place you on pretrial release. At this time, you're not allowed to have any contact with the victim. You understand what no contact means? You can answer me now.
Oh, yes, ma'am.
All right, so you can't send a message through friends or talk to her on social media, nothing. You're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to return to the scene. You don't have any belongings here, right?
I'm sorry?
You don't have any belongings here at this apartment
What do you,
that you need.
I would have my, well, I don't, it's a tough situation because I do have things at her house, but she's my girlfriend and I don't have any other place necessarily to go and she knows that.
It doesn't matter. I'm ordering that you're not allowed to return there.
I understand. I do have my work clothes and I had like $100 that I really put in to give to her.
All right, I'll order that you must maintain a separate residence. I'll allow a one-time return with law enforcement officers to gather your belongings. I'll also order that you comply with any treatment recommended by a provider while you're out.
Can I say something else?
Yes.
His sister and brother has all of his belongings.
All right, so he doesn't have anything at your apartment now?
No, and when he gets released, they're having him set up to go to a place to get help.
All right, so I'm going to order that you're not allowed to return to her residence for any reason because your belongings aren't there.
Yes, ma'am.
And if you find that something is there, you can always ask your attorney to file a motion in front of the trial judge. You understand? All right, good luck. Thank you, ma'am.
So Your Honor, you want me to strike maintain separate residence and one?
Yes,
return?
no return. Yes. No, you may not speak to her. I just ordered you not to have any contact. So you're not allowed to speak to her for any reason at all.
Can I ask for your permission?
No. You may not speak with her.
What did you just strike? I didn't.
Maintain separate and one-time return, it's no return at all. I mean, so I guess maintain separate is still the same, but the one-time return is not. Please tell me your name.
Ilafa Hamid. Okay.
In case number 21MM171580, you're here charged with battery, dating, violence. I'll appoint the Public Defender's Office to represent you. Sir, do you wish to testify?
Yes.
Please raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Martise Heath, Heath.
May I inquire?
Yes, please.
Good afternoon, sir. Can you please state your relationship to the defendant?
Girlfriend.
And how long have you known her?
For some years, but we just started dating for like 5 months.
Okay. And are you afraid of her?
No.
If she were to get out of jail today, would you be afraid of her?
No.
Were drugs or alcohol involved in this altercation?
No.
And has anything like this ever happened before between the two of you?
Never.
And if anything were to ever occur in the future, would you be willing to call 911?
Yes.
And lastly, if she were to get out of jail, would you want to have contact with her?
Yes.
That's all I have, Your Honor.
Does the defense wish to inquire?
No questions.
If the interview had been completed, would she qualify for pretrial release?
Yeah, she can qualify, Your Honor.
All right.
Will you allow her to return back to Michigan?
Yes. I'm going to place you on pretrial release with special conditions. Did you say you do want contact?
Yes.
I'll allow peaceful contact. Do you understand what that means?
Thank you.
You can't even raise your voice. I'll order that you're not allowed to possess a weapon of any kind, firearm or ammunition. Any other conditions the state would request?
No, Your Honor.
All right, good luck, ma'am. And I'm appointing the public defender. Thank you, sir.
Thank you.
Can we call back Mr. Daniel? I just want to get the Spanish interpreter before I think they break at 12.
Good morning. This is Dalia Romero, Spanish interpreter on the line.
Good morning, ma'am.
Already
This is
sworn
Judge
in.
Gibson.
Yes, Your Honor.
We have the same defendant. We've been unable to get an interpreter for the dialect that he speaks. And I asked if he understands English, and he said no, but he does understand some Spanish.
Yes.
So I want to recall him and see if, at the very least, we can communicate to him that we will try to order another interpreter for tomorrow, and I'm appointing the public defender's office and tell him what his bond is.
Yes, Your Honor. If you will allow me some lead voice space there so that I can tell him in Spanish slowly what's going on.
Yes. So
May
it's
I?
case number
Thank you.
21 CF 2890, and he's charged with aggravated child abuse.
Thank you.
Oh, wait, the headphones aren't on yet. They're putting them on.
Yep.
Pero, ok, está bien. Una pregunta, disculpe. Yo puedo hablar bien español. Él me puede explicar. Sí, el problema no hay ningún problema, yo entiendo todo, nada más que no entendí lo que me dijo la jueza, por eso.
Your Honor, he says that he can understand Spanish. He just did not understand at first what you told him the charge was. I've gone over that with him. Does he have a bond?
He will, but he also has an immigration hold.
Señor,
Sí, yo lo entiendo. Eso lo puedo pagar la fianza, entonces no puedo salir.
Okay, I understand. So, can I pay the bond, but I still cannot get out?
Most likely, yes.
Okay, está bien.
Okay, very well.
Your bond is $2,000. You're not allowed to possess a weapon, firearm, or ammunition. And you can't have unsupervised contact with the child or any other children under the age of 18.
Okay, yo cumplo lo que ellos dicen, pero ¿tengo salida o no?
Okay, I will comply with what you assign, but can I get out or not?
Most likely, no. You have an immigration hold.
Okay, está bien. Entonces, otra pregunta, disculpe. O sea, ahorita salgo de aquí y me mandan a inmigración.
Okay, another question, I'm sorry.
Yes.
So, when I leave here, are they going to send me to immigration?
They'll hold you here, and immigration will decide if they're going to come and get you.
Okay, está bien.
Okay, very well.
So I appointed an attorney to represent you. You can talk to your attorney about those questions.
Okay, está bien.
Okay, that's fine.
All right, good luck, sir.
Okay, gracias.
Okay, thank you. Your Honor, may I have a spelling of the defendant's name, please?
Just a moment. His last name is Caalquej.
Thank you.
Thank you, ma'am.
You're welcome. Have a great day.
You as well. Please tell me your name.
Trisha Corica.
21MM168480. You're here charged with battery, domestic violence. I'm appointing the Public Defender's Office to represent you. There is probable cause in this case. Patricia Corica. She qualifies for pretrial release. What says the state?
The state has no objection if she otherwise qualifies, as we do not have a victim here to testify.
I'm going to place you on pretrial release. You're not allowed to possess or consume any alcoholic beverages, and you'll be subject to random alcohol screens. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You understand what no contact means? Did you say yes?
Yes, ma'am. I'm sorry.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. Good luck.
Thank you, ma'am.
Please tell me your name.
Dominique Garrett.
In 21MM171980, you're here charged with battery domestic violence. I'm going to appoint the Public Defender's Office to represent you. Counselor, did you wish to be heard?
Yes, Your Honor. In this case, we're arguing.
Can you get closer to your microphone? Sorry, it's the opposite direction you're leaning.
In this case, we are arguing PC on the battery. If you look at the facts of the case, he was the victim. He was the one that was, I wanted to say stabbed, but cut. And he asked the police to allow him to help calm his girlfriend down. And at one point, he grabs her to try to hug her to calm her down, and he charges him with.
I'm sorry.
He charges him with a battery in this case. Your Honor, we would just ask for no PC. This is a situation where he's the victim. He's trying to calm his girlfriend down. He grabs her and gives her a hug. This is his girlfriend, to try to calm her down because the police were there. And they arrest him and charge him with battery for touching her.
Say something.
What says the state?
Your Honor, I understand the circumstances that happened with this case. We had Miss, I believe, Amani here earlier. But under battery, that we have to prove and actually intentionally touch the victim against her will. It does say that he reached out and grabbed her by her right arm and pulled her back into him, which would seem to reason that it was against her will. However, I do understand the circumstances around this case and the leeway that the officer gave the defendant to try to calm down his girlfriend. However, I would argue that he did, at least what is written in the affidavit, touch Amani against her will.
Your Honor, we would just argue that this is a situation. My client is currently on probation. He's going to get charged with the battery for trying to calm his girlfriend down after she stabbed him, and he's arrested, after asking the police to allow him to calm her down because she was irate. And the state is going to charge him with the battery, and he's going to be held here. He's going to violate probation in a situation where he's the victim.
Counselor, I appreciate your argument, but it says in the probable cause affidavit, she attempted to walk away. He reached out, grabbed her by the right arm, pulled her back, and hugged her for the purpose of trying to calm her down. But there's two elements the state has to prove for battery, right? An intentional touching against someone's will. So I'm not saying this is beyond all reasonable doubt. I'm not saying the state will even pursue this. I don't know that they will. But for purposes of probable cause, which of those elements is missing here?
Your Honor, there is no, even though she walked away and she pulled away, she was upset. He asked the police to let him touch her. I'm arguing, she never once did she say she did not want him to touch her. He was trying to calm her down. So although, yes, he touched her, be quiet. Allegedly against her will. In a normal situation, this would not be a battery. He's hugging her. He's the victim. He's trying to calm her down. He grabs her because she's irate with the police officer there. He asks permission. And although she's walking away, she's upset. So he's trying to get her to calm down before she gets into more trouble. And they slap cuffs on him and charge him with battery. And now we're going to bring him here. He's going to violate probation and be held in jail. Be quiet.
Okay, I'm sorry. She never said I couldn't touch her.
Could you stop, please?
Okay, I'm done talking.
It's a misfortunate situation, Your Honor, to charge someone with the battery when he's trying to calm his girlfriend down and he's the victim.
Counselor, I agree with you. This seems like a very unfortunate situation. But I think there's probable cause. It's an intentional touching against her will.
The only thing the officer had to state that it was against her will is because she moved away. Your Honor, she's upset.
She didn't give him permission, right?
Quiet. It's not gonna matter. Go ahead.
Okay.
He wants to say something.
Ma'am.
So
She didn't walk
I advise against it. He
she
wants to
didn't-
talk.
Okay.
She didn't walk away from me. She wasn't walking away from me. We was talking face to face. The officer was letting us talk. I'm
Right.
like, babe, calm down, because she tripping on him, not me.
Right.
She was not mad at me.
After she stabbed you?
After I'm telling her, like, calm down, man. Calm down. Calm down. She like, all right. So she tell me, let's go home. So I grab him like, but she's so aggressive, and she's scaring the officer. So I'm like, come here, man. And cause I know her. So I had to, give me a hug, babe. And she gave me a hug. She hugged me back. She hugged me back, man. I wasn't the aggressive. I got stabbed. She hugged me.
Right. I understand you're definitely the victim of the stabbing. And again, I don't know what the state's gonna do with this, but let me tell you what the court's looking at. We're not having a trial today. I'm not saying the state can even win this case, or they can't. I don't know what the state will do. But in order to determine if there's probable cause, the crime of battery for which you've been charged has two elements. One is that you intentionally touched her, which the probable cause affidavit says that you did. And the second one is it's against her will. That's the one that the state might have problems proving. I'm not telling you they can prove that beyond all reasonable doubt. But probable cause is a determination that says more likely than not you did this.
No, you have to come back.
So here's what I think I will do at this time. Oh, he's a violent felony offender of special concern. What's his probation?
Drug related.
It's drug related,
Oh, I'm so sorry.
not violent?
Felony, battery, and tampering with witness.
Felony battery.
I'm off that felony battery probation. I just completed the probation off that. I'm not even on probation for that no more.
You might not be, but I have a detainer for you as a violent felony offender of special concern, and that you are on state probation
Yes, I am.
for not the felony battery?
Not the felony battery no more. No, ma'am.
Can I see the attorneys? All right, Mr. Garrett.
Yes, ma'am.
We're going to recall your case in 24 hours. I'm going to give the state 24 hours to work on their case. Your attorney will as well. We'll call your case again tomorrow, so we're going to reset this for tomorrow.
Okay.
Good luck, sir. Yes, sir, good luck. And then Dexter, after the misdemeanors, we're gonna take a break. Okay. Please tell me your name.
Jermaine Harris.
Case number 21MM168680. You're here charged with battery domestic violence. Please look at me.
Yes.
I'm going to appoint the public defender's office to represent you. There is probable cause in this case. Ma'am, do you wish to testify?
No, he's actually completely innocent, Your Honor.
Wait. Do you want to testify?
What's that mean?
Do you want to speak to the court today?
Yes.
Then you need to raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name for the record and spell your last name.
Lisa Mazzola, Mazzola.
May I inquire?
Yes, please.
Good afternoon, ma'am. Can you please state your relationship to the defendant?
My boyfriend of 2.5 years.
Okay. And are you afraid of him?
No.
If you were to get out of jail today, would you be afraid of him?
No.
Did drugs or alcohol play a part in this altercation?
Alcohol.
And has anything like this ever happened before?
No.
And if anything like this were to happen again, would you be willing to call 911? Or if you were ever placed in a situation that you felt threatened?
No, he's never hurt me or anything. My friends in the hotel admitted that they were the ones that hit me. I got in between them fighting, and everyone was drunk, arguing. There was 5 of us in the hotel. He was being, verbally mean to me, so at first I thought it was him. Everyone was blaming him. But I realized later it wasn't. And then he was crying to the police, I didn't even do anything. He was crying his eyes out, and I even spoke to him on the phone. He said, I didn't even hit you, why did this happen? And then on the ride home, I live 2 hours away. On the ride home, my friends admitted to me that, yeah, he never hit you. We accidentally hit you when you were trying to break us up.
Okay, thank you.
We were with another couple that was fighting, and I got, I had my head down, trying to break them up and, try not to get hit. But yeah, I got accidentally hit.
That's all I have, Your Honor.
Does the defense wish to inquire?
No, Your Honor.
All right, sir, your bond is $500. At this time, I'm going to order that you're not allowed to have any contact with each other. So you can't have any contact with her for now. Do you know what no contact means?
Yes, ma'am.
All right, so no electronic communication. You can't call her on the phone or send a message through your friends. All right, you're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to possess or consume any alcohol, and you'll be subject to random alcohol screens. Do you live here?
No, ma'am.
Where do you live?
Fort Pierce.
All right, I'll allow you to return to Fort Pierce, but I'm going to order that you maintain a separate residence. So you guys can't live together right now. You understand? All right, good luck. Thank you, ma'am.
I was gonna bond him out today as well. Am I able to do that?
You can do that, but he can't talk to you.
Can I ask why that is?
Yes, I'm ordering him not to have any contact with you at this time.
Why is that? He didn't even hit me.
Yeah, I understand that's what you're saying today, but that's very different from what's in the probable cause affidavit. So based on what I read, I'm not going to allow you to have contact at this time. I think sometimes it's better to just have some space. So his attorney can file a motion in front of the trial judge for contact, and/or if the state attorney's office drops the charges, then there won't be any.
Right, we were all drunk. I didn't realize till later that he didn't even hit me. My friends left the hotel. They were ready to pack their stuff in the car. We didn't even get to go to Universal Studios. I had to drive 2 hours back home. And I didn't realize what happened till later.
I understand.
So I
But
was
for
wrong,
now,
and I'm very sorry.
my order is
you know.
going to stay.
Okay.
Good luck, ma'am. Thank you for coming. Good luck, sir.
Thank you.
Please tell me your name.
Robin Love.
21 MM 168580. You're here charged with battery, domestic violence. I'll appoint the public defender's office to represent you. There is probable cause in this case.
The state will be asking for PTR as he qualifies.
I'll place you on pretrial release. You're not allowed to have any contact with the victim. I'll order that you maintain a separate residence. Do you need to go to this residence to gather your belongings?
Yes, ma'am.
I'll allow one-time return with law enforcement to gather your belongings. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Yes, ma'am.
Good luck, sir. Please tell me your name.
Gabriel Ramos.
21 MM 147AW. You're charged with battery, domestic violence. There is probable cause. I'll appoint the public defender's office to represent you.
Your Honor, we would ask for PTR. It's showing that he has no criminal history and employed full-time.
I'll place you on pretrial release. You're not allowed to have any contact with the victim. Do you know what no contact means?
Yes, ma'am.
Not through the telephone, not through social media. You can't send a message through family or friends. I'm further going to order that you're not allowed to have any unsupervised contact with your son or her son. Do you have belongings at this house you need to gather?
Yes.
I'll order that you maintain a separate residence. I'll allow one-time return with law enforcement to gather your belongings. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to have any unsupervised contact with any minors under 18. Are there any other conditions the state would request?
No, Your Honor.
Good luck. Thank you, sir. Oh, you want to take a break now? Oh, I just had more in this pile, but if you're ready for a break?
That's all I had.
With the traffic?
Well, I got to take a break at some point soon. Is now a good break time? Let's break. Okay, court will be in recess for, is 10 minutes good?
Yes.
10, okay.
John Doe refused, Your Honor.
Oh, that's not who I have next.
Okay. Oh, I didn't-
Who's move up?
Okay.
I have Christina Figueroa. Please tell me your name.
Christina Figueroa.
All right. You're here because a capias was issued for your arrest in case number 20 CT 139780 for driving under the influence, a failure to appear for arraignment. At this time, there is no bond set. I'll appoint the public defender's office to represent you. Good luck. I don't have a John Doe right now. Do you have it?
It got
All right.
moved up.
Please tell me your name.
Howard Wilson, Your Honor.
You're hearing case number 21 CT 284, charged with driving while license suspended. Subsequent offense. There is probable cause. I'll appoint the public defender's office to represent you.
Your Honor, we would ask for pretrial release.
I'm going to place you on pretrial release unless the state has any objection. The only condition will be, I'm sorry?
Is Mr. Wilson
Yeah.
correct?
Wilson, yes.
We're asking for pretrial release.
The state has no objection to pretrial release, given that he qualifies and he has, it's a nonviolent offense that he's currently on.
All right, you can't drive without a valid driver's license. You understand?
Yes, Your Honor.
All right, good luck.
Thank you, Your Honor.
Then I have arraignments.
Okay.
Twenty-one CT 1634. Counselor, your office represents him on a Dwillis charge.
We'll waive, Your Honor.
82.
Division 82, pretrial conference date will be April 19th, 10:30 a.m., courtroom 10B.
And, sorry, enter a plea of not guilty.
Okay. Next,
Terrence Ingram?
Mr. Terrence Ingram.
Yes, ma'am.
All right, 21 CT 1639. You're here charged with driving while license suspended, and you're represented by the Office of the Public Defender. This is a Division 85 case.
Yes, Your Honor, the state is offering, withhold of adjudication credit for the time served, on the case. We're gonna enter a plea of, we're gonna accept the state's offer and enter a plea of, no contest, Your Honor.
And he doesn't qualify for pretrial diversion?
Not at in-jail arraignment, no, Your Honor.
I'm sorry?
So not currently at in-jail arraignment. He may, if this case were to continue and he was to go to downtown.
I just want to make sure you explain that to him, because if he qualifies for that program, I want to make sure he knows.
Yeah, just a moment, Your Honor, I'm gonna double check, but.
Yes.
The notes that I saw. Your Honor, we're gonna. Your Honor, my client understands all of his rights. He wants to resolve the case today, and enter a plea of no contest.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
All right, sir, so you had an opportunity to speak to your attorney about this, and you want to enter a plea of no contest today?
Yes, ma'am.
And she explained all the rights you're giving up by entering that plea?
Yes, ma'am.
And also, you understand that the state might have a diversion program that you might qualify for. I have no idea if you do. But if you enter a plea of no contest today, you're not going to go into diversion. I'm going to accept your plea and sentence you today.
Okay.
That's what you want to do?
You have to speak.
Yes.
You have to say it out loud because we're making a record.
Yes, ma'am.
All right. You understand if you're on probation, this plea could violate that probation?
This plea can violate this probation?
Yes, if you're on probation right now.
Yes.
I'm not saying you are.
He is, Your Honor.
Well, no.
He is on probation? So you understand that by entering a plea, this could violate your probation?
Yes,
I want to enter the plea.
he doesn't want to take the plea now, Your Honor.
Okay. All right, we'll enter a plea of not guilty on your behalf, and it'll be set for your next court date.
April 5th, 9 a.m., courtroom 4A.
So just maintain contact with your attorney, okay?
Yes, ma'am.
Not guilty. We're going to enter plea of not guilty, sorry.
All right, good luck, sir.
Division 85, correct?
Yes.
Thank you.
I said it like 8 times. You can do that. I said it 8 times to him, and he's like, no. Yeah.
Please tell me your name.
Desiree Charles McGee.
Oh, all right. This is case number 21MM1721. You're here charged with petty theft with a prior theft conviction. There is probable cause. I'll appoint the public defender's office to represent you.
The state is offering an adjudication of guilt, credit time served, no return to Walmart. I did go over her rights that she'd be giving up if she accepts the state's offer today, and she wants to accept the state's offer.
She's out on bond, counselor.
Yes, Your Honor, it's set for a pretrial conference on 4/13, and my notes state that they were going to resolve the case at that point.
I'm sorry. I couldn't hear the last part.
Sorry, she set on April 13th, and it was stating that she was going to resolve her case at that time.
So I'm inclined to revoke her bond. Before I accept a plea from her, I wanted to tell you that and see if you have any argument as to why I should not.
Your Honor, because it's set to plea out, we are going to resolve the petty theft today. And although it is a new charge, she's going to resolve that one and the carrying a concealed firearm on April 13th. And at this time, because the new charge she picked up is not a violent one, we would just ask that you not take any action. I see that her last failure to appear was in 2006. And for that reason, we would ask that you don't take any action.
What says the state?
I cannot speak as to whether or not she's going to plea on the 13th. All I have is it set for pretrial in Division 19. Her last failure to appear was 2006. However, she does have two failures to appear, showing a little bit of a pattern. And her last conviction was 2017. So it's been semi-recent. The current offense is nonviolent. However, she does have a fairly lengthy petty theft history, all from 2006. I do have, I believe, 3 of them.
Normally, when we take the offer from the state, you don't take any action on the out-on.
So,
fine.
All right, and ma'am, did your attorney explain to you that petty theft is an enhanceable crime and that at some point the state can charge you as a felon?
Yes, she explained that to me.
All right, you understand that?
Yes, ma'am.
Raise your right hand, please.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes, ma'am.
Your attorney informed the court that you're interested in accepting the state's offer, is that correct?
Yes, ma'am.
And you understand the rights you're giving up by entering a plea of no contest today?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand that if you're on probation, this plea could violate your probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
At this time, how do you wish to plead to the charge of petty theft with a prior conviction?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
2 days.
2 days in jail. Is there restitution, counselor?
no, Your Honor, they recovered all the merchandise.
I'll order that you pay court costs. I'll give you a year to pay it. Were there any other conditions? And you're not allowed to return to Walmart.
Correct.
Is there anything else in the state's plea agreement?
No, Your Honor.
All right, good luck, ma'am.
And no action on the,
And I'll take no action on the out on bond case. Please tell me your name.
Hiram Lionel Cordones, ma'am, Your Honor.
In 21 MM 1712, you're charged with petty theft, $100 or more, and resisting an officer without violence. I'll appoint the public defender's office to represent you. There is probable cause.
Your Honor, I did speak with him. The state's offered an adjudication of guilt, credit time served, and no return to home depot. I spoke with the client. He's willing to accept the state's offer at this time.
Did any of them sign plea agreements?
No.
All right, if we can go back to that, if we can have them do that, that will also help.
Yeah, because of COVID, it's kind of hard, Your Honor. So I try to talk to him and I bring him out here and I go through everything with him. As you see, I spoke to him and I went through everything in the one before that.
All right, please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
No, I do.
Did you say yes?
I do. Yes, I do.
You have to speak up.
Yes.
You have to leave the mask on, just speak up. All right, thank you. So your attorney explained to you all the rights you're giving up if you enter this plea today, is that correct?
Yes, ma'am.
Do you have any questions about those rights?
Yes, ma'am.
Do you understand if you're on probation, this plea could violate that probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
At this time, how do you wish to plead to the charge of, let me ask you this. You understand that petty theft is an enhanceable offense. So after 2 convictions for petty theft, the state can charge you as a felony if you commit a 3rd petty theft. Do you understand?
Yes, ma'am.
How do you wish to plead to the charge of petty theft and resisting an officer without violence?
No contest, miss.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
2 days.
2 days in jail. I'll order that you're not allowed to return to Home Depot. I'll order that you have to pay court costs. I'll give you a year to pay them. Was there anything else?
No, Your Honor.
All right, you have 30 days to appeal in writing. Good luck, sir. Please tell me your name.
Eric Figueres.
In case number 21MM170580, you're here charged with violating a county ordinance. I'm going to appoint the public defender's office to represent you.
Your Honor, I spoke with the client and the state's offering him an adjudication of guilt, credit time served, and no return to the scene. He's willing to accept the state's offer.
All right, sir, raise your right hand to be sworn.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, I do.
Your attorneys informed the court that you wish to accept the state's offer today, is that correct?
Yes.
She explained to you the rights you're giving up by entering this plea. Do you understand those rights?
Yes.
Do you have any questions for me about them?
No.
Do you understand that if you're on probation, this plea could violate that probation?
Yes.
Do you understand if you're not a United States citizen, this plea could subject you to deportation?
Yes.
At this time, how do you wish to plead to the charge of violating a county ordinance?
No contact.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll give you credit. I'll adjudicate you guilty, give you credit for
2 days.
2 days in jail. I'll order you're not allowed to return to the scene. I'll order you to pay court costs, give you a year to pay them, and I'll take no action on your out on bond cases. Good luck. Stephen Haddon. 21MM1693. I'm going to appoint the public defender's office to represent him.
Your Honor, we'll waive and ask for an ROR in his case. We have some competency concerns. I think it was 2017, he was deemed incompetent. And although in November, they did an evaluation and he was okay to plead, stating that he was competent. He keeps doing the same thing and he has these mental health concerns. So I'm believing that he's gonna need a new evaluation. So we would just ask for an ROR.
What says the state?
Your Honor, he just pled 3 days ago, also to a trespass. No objection, that's fine.
I'll release him on his own recognizance, order that he's not allowed to return to the Lynx bus station, and order that he stay in touch with his attorney. Thank you, counselors. Please tell me your name.
Ellie Hoffman.
21MM1700, you're here charged with petty theft, retail. I'm appointing the Public Defender's Office to represent you. There is probable cause. Counselor?
Your Honor, I did speak with Ms. Hoffman, and the state is offering an adjudication of guilt, credit time served, and no return to Walmart. Also on the petty theft, the case that she's out on bond, it is a withhold of adjudication, credit time served, and no return. If I can have a second, because I just got the one for the out on bond case, the offer, if I can just speak with her. Okay, so we're gonna accept the state's offer in both cases, Your Honor. I did already go over the rights that she'd be giving up if she accepts the state's offer, and I did go over the enhanced, if she gets a third petty theft, that it will be enhanced, it could be enhanced to a felony. After going through that, she did state she wants to accept both offers from the state.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
I do.
All right, your attorney advised the court that you want to enter a plea today to both of these cases, and you understand the rights you're giving up. Is that correct?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
You understand if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
And you understand that petty theft is an enhanceable offense?
Yes, Your Honor.
So at some point, the state can charge you with a felony?
Yes, Your Honor.
All right, how do you wish to plead to the charge of petty theft in case number 20MM7968?
No contest?
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, order you to pay court costs, and give you credit for,
Are we talking about the out on bond case here?
yes.
She really hasn't served time on that.
I was gonna say, I don't think she was in jail.
It was an NTA.
It was an NTA, so she has no credit on that case.
Basically just.
1 day.
And then in case number 21MM170080, how do you wish to plead to petty theft, retail?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
2 days.
2 days in jail. I'll order that you're not allowed to return to Walmart. I'll order that you pay court costs, and I'll give you a year to pay them. You have 30 days to appeal in writing.
Thank you, Your Honor.
Yes, on both cases. Good luck. Please tell me your name.
Susan Johnson.
This is case number 21MM97AA. You're charged with petty theft. I'm going to appoint the Public Defender's Office to represent you. Counselor, do you wish to be heard?
Yes, Your Honor, we would just ask for a ROR in this case. She would qualify for pretrial diversion.
If you're looking at the PC argument.
Yeah. Yes, I am.
State would just argue principal theory that she was distracting the clerk while her co-defendant, Mr.
Matthews.
Yes, Your Honor. Why Mr. Matthews placed things in his bag, because then they got together and left therefore after. So state would argue that it was a principal theory, petty theft. And under that theory, there is probable cause.
All right, what says the defense?
Your Honor, we would ask for an ROR And based on that, no PC, being that she was not the one stealing any items.
So I was struggling with the PC, counselor, until the state said, under the principal theory, that's how they're arguing the probable cause. Can you address that?
No, Your Honor, that's why I asked for an ROR.
Well, I'm going to release her on her own recognizance, but I'm going to find PC under the principal theory. Ma'am, you're not allowed to return to that Wawa, and you're not allowed to have any contact with Gregory Matthews. Do you understand?
I do, Your Honor.
All right, good luck. Please tell me your name. 21MM170980, you're here charged with trespass on property after warning. I'm going to appoint the Public Defender's Office to represent you.
Your Honor, the state in this case is offering a withhold of adjudication credit time served, no return.
Counselor, I'm not going to do a withhold. I will adjudicate him guilty based on his criminal history, but I will give him credit for the time he spent in jail and order him to pay the court costs and give him a year to pay it.
Okay, can I just speak with him, Your Honor?
Yes.
Yes.
Lake and right. You know, what your positions are as far as behind.
Okay, Your Honor, he's willing to accept the adjudication of guilt, credit time served, no return on his case. And
His chances to get into loss.
yep, and I went over all the rights he would be giving up if he accepts the state's offer today, and he wants to accept the state's offer.
All right, thank you, Counselor. Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
I do.
Sir, your attorney has informed the court that you want to enter a plea of no contest or guilty today. Is that correct?
I do.
And you do understand all the rights you're giving up? You have to answer out loud. You understand if you're on probation, this plea could violate your probation?
Yes, I do.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, I do.
At this time, how do you wish to plead to the charge of trespass on property after warning? I'll accept your plea of guilty. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
2 days.
2 days in jail. I'll order you're not allowed to return here, sir. I'll order you to pay court costs, give you a year to pay them. And you still have sex offender reporting requirements. You must maintain those requirements. You understand? All right. Good luck, sir. You have 30 days to appeal in writing.
Thank you, Your Honor. Gregory Matthews, Your Honor.
21MM98, petty theft and possession of drug paraphernalia. I'll appoint the Public Defender's Office. I do believe there's probable cause here, Counselor.
Yes, Your Honor.
His bond is $500 on count 1, $100 on count 2. No contact with the co-defendant, not return to Wawa. Not possess or consume illegal substances. And I find his refusal to come to court a willing waiver of his presence. Please tell me your name.
Scott Philip Dwayne Scott.
I'm sorry, tell me one more time.
Philip Dwayne Scott.
In case number 21MM148AW, you're here charged with resisting an officer without violence. There is probable cause. I'll appoint the Public Defender's Office to represent you. Your bond is $500, but I think you have an open violation of probation warrant as well. All right, good luck, sir. Please tell me your name.
Lindsay Fleming.
In case number 21MM13780, you're here charged with stalking. A warrant was issued for your arrest.
Yes, ma'am.
I'll appoint the Public Defender's Office to represent you. Does either party wish to be heard on bond?
I'm not, I'm trying to see why she doesn't, oh, because of the offense, is that why she doesn't?
She can qualify for
We would just ask for pretrial release, Your Honor. My client has no criminal history and is employed full-time.
Given that there's no input from the victim, the state would just ask for a reasonable bond.
I mean, pretrial release will monitor her. If she does anything, she'd be brought back here before you, Your Honor. And with no criminal history, I don't see why she would not qualify for pretrial release as opposed to a monetary bond, which the court should look at pretrial release before giving a monetary bond.
Stalking is not considered an,
No, they actually, they okayed that charge to be qualified for PTR, along with aggravated assault, aggravated battery.
Ms. Fleming does have an 18 juvenile case that she pled no contest to and then violated probation on, and she currently has a 21 non-arrest case that is.
She has a what?
A 2021 non-arrest case that is pending making a filing decision.
What is that case?
Assault.
Assault?
Yes, Your Honor.
Do you have the victim?
It is Miss Red and Miss Ritter.
That's the same victim.
We would just argue that there is no filing decision made in that case, Your Honor. And because of that, her juvie record, she has a juvenile record, but that was when she was a juvenile. And at this time, she has an arrest that has not been filed on. And because of that, we would ask for pretrial release.
I do believe that non-arrest or that non-arrest became from the same incident with the stalking, Your Honor.
It's the same incident?
I believe so, yes.
Okay. Ma'am, where do you work?
I work for my mother.
I couldn't hear you. One more time.
All-State Striping, and my mother owns her own company. I work for her.
All right. I'm going to place you on pretrial release, but I'm additionally going to put a $1,000 bond on the charge of stalking. You're not allowed to have any contact with the victim. Do you understand what no contact means? You can't send a message through friends or family, contact her on social media, no contact at all.
Yes, ma'am. I know that. I haven't had any contact.
Don't talk about the facts of the case.
You're not allowed to be within 1,000 feet of the victim. You're not allowed to possess a weapon of any kind, firearm or ammunition. Which also means you're not allowed to return to her residence for any reason. Do you understand? That includes the parking lot of her residence. You can't be there in your car. Do you understand? Are there any other conditions the state would request?
Not at this time, Your Honor.
I'm also going to order that you're not allowed to have any contact with any witnesses in the case. All right, good luck.
Thank you.
Please tell me your name.
Richard Andrew Hadalack.
In 19 MM 475BO, a warrant was issued for your arrest for failing to appear for pretrial conference on a charge of trespass on property other than a structure. I'll appoint the public defender's office to represent you. Did the state have an offer?
Yes, Your Honor. An adjudication, credit time served, and no return to the construction site with SGL constructors.
Did you talk to your client about that, Ms. George?
No, I didn't see that one.
I'm sorry?
No, not on that one, Your Honor.
Okay.
This is a 2019 case, so I'm assuming the construction site is probably no longer a construction site, but.
Good thought.
gonna plead no contest. I went over the rights that he be given up, and he wants to accept the state's offer today.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
I do.
Thank you. Thank you, Counselor. All right, sir, you understand that if you enter a plea today, you're giving up the rights that your attorney just went over with you.
Correct.
Do you have any questions for me about those rights?
The name of the company will be on the paperwork.
Yes.
I'm fine then, thank you.
But like your right to remain silent, your right to testify, we're not having a jury trial, you understand all those rights?
And those, yep.
All right. You understand if you're on probation, this plea could violate that probation?
Yes.
You understand if you're not a United States citizen, this plea could subject you to deportation?
I understand.
At this time, how do you wish to plead to the charge of trespass on property other than structure or conveyance?
No contest, Your Honor.
I'll accept your plea. I find it's freely and voluntarily made. I will adjudicate you guilty, give you credit for
4 days.
4 days in jail. I'll order that you're not allowed to return to, Counselor,
SGL Constructors.
any SGL construction sites.
Yes, Your Honor.
I'll give you a year to pay your court costs, and you have 30 days to appeal in writing.
How much is the total?
It's roughly $300. I don't know the exact amount to give you, but it's
He'll tell me when
30 something, 306 maybe? Yes, it'll be on your paperwork and how to pay it. So I've given you a year to pay, but if you pay it sooner, you're done. So, yes, sir, good luck. Please tell me your name.
Christina Romero.
Case number 20MM4826, you're here for failing to appear for pretrial conference on a charge of trespass on property other than structure or conveyance. Your bond is $500.
Your Honor,
I'll appoint the public defender's office.
the state's offering an adjudication of guilt, credit time served, and no return to the Wawa. I've spoken with my client, went over her rights, and she wants to accept the state's offer and enter plea of no contest.
And she has 4 days.
Raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes.
Your attorney's informed the court that you wish to enter a plea today, is that correct?
Yes, Your Honor.
And you understand the rights you're giving up by entering a plea?
Yes, Your Honor.
You understand if you're on probation, this plea could violate that probation?
Yes, Your Honor.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, Your Honor.
At this time, how do you wish to plead to the charge of trespass on property other than structure or conveyance?
Oh, no contest, and the result is today.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for 4 days in jail. I'll order you're not allowed to return to that Wawa. I'll order you to pay court costs and give you a year to pay them. You understand?
Okay.
You have 30 days to appeal in writing. Good luck.
Thank you.
Please tell me your name.
Gabriel Rosario Rodan.
In case number 20MM2536, a capias was issued for your arrest for failing to appear on a charge of petty theft with a prior conviction. Your bond is $1,000. I'll appoint the public defender.
Your Honor, the state is offering an adjudication of guilt, credit time served, cost of investigation of $53 to OPD, restitution in the amount of $3.98 to Wawa and no return. My client has already went over all of his rights with the public defender's office. He's our client, and he wants to accept the state's offer here today.
Please raise your right hand.
Do you swear to tell the truth, whole truth, and nothing but the truth, help you God?
Yes, I do.
You heard what your attorney just said. Is that what you'd like to do here?
Yes, ma'am.
You understand all the rights you're giving up by entering a plea?
Yes, ma'am.
You understand if you're on probation, this plea could violate that probation?
Yes, ma'am.
You understand if you're not a United States citizen, this plea could subject you to deportation?
Yes, ma'am.
At this time, how do you wish to plead to the charge of petty theft with a prior conviction?
Guilty, sir. Guilty, ma'am.
Did you say guilty?
No
Or
contest.
No contest.
Contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
3 days.
3 days in jail. I'll order you to pay the $53 cost of investigation to, did you say Orlando?
OPD, yes, Your Honor.
I'll order that you pay $3.98 in restitution to Wawa. You're not allowed to return to Wawa. I'll order you to pay court costs and give you a year to pay them. Do you understand?
Yes, ma'am.
And your attorney explained to you that petty theft is an enhanceable offense.
Yes, ma'am.
So after a certain number, the state can charge it as a felony.
Yes, she mentioned 3 of them.
All right. Good luck, sir.
Thank you.
Please tell me your name.
Jonathan Blake.
Case number 21MO310. You're here for violating state misdemeanors. I'll appoint the public defender's office.
Your Honor, there is an offer of a withhold on credit time served.
Your Honor, on this case, we would ask for a ROR.
All right. What says the state?
He is currently out on ROR for possession of meth. I do not believe that case has been filed on yet. However, the state would object to an ROR due to him being out on ROR and picking up this new case.
And I kept,
Your Honor, it's a city misdemeanor case because it would be a withhold of adjudication credit time served. My client is disputing the facts in the arrest affidavit, and because it's a nonviolent offense, I see 0 failures to appear. We would ask for a ROR. He is currently unemployed, Your Honor, so he would not be able to post bond. In this case, we would just ask for an ROR. Normally, we would resolve these cases here today.
All right, I am going to release you on your own recognizance,
thank you.
but I'm going to revoke your ROR in your open case.
What does that mean? I don't know what that means.
It means you're out on bond on a case and you got arrested for a new case, and I'm revoking that ROR. But I'm going to set a bond.
Your Honor, if you revoke his out on bond case, he is unemployed. He's not going to be able to afford it. And the fact that he's disputing that this ever even happened the way that the arrest affidavit says, and it's a nonviolent case, it's a city ordinance case where they would do a withhold and a credit time served anyway. And we would have resolved it had he not wanted to fight it downtown.
I'm getting overheated, sir.
We would ask for an ROR.
Sir, calm down.
I'm getting overheated. I have seizures. That's why I walked away from the cop to begin with. Because of the lights.
Okay, calm down. Your Honor, we would ask for an ROR. This isn't even a violent offense. It doesn't make sense to revoke his out on bond case on a city ordinance case when we would have resolved it today. And again, I would just point out he has 0 failures to appear.
All right. I'm going to change my order. I'm not going to revoke your ROR, sir. Does a state misdemeanor charge qualify for mental health pretrial release?
He can be screened for it.
All right, I'm going to have him screened for mental health pretrial release in the state misdemeanors case, and I'm not going to take any action on his out on bond case. No,
Your Honor, in the alternative, if he does not qualify for mental health pretrial release, can we set him for ROR or pretrial release? I don't know which one.
Qualify for pretrial.
Well,
case.
could we?
he will.
He won't qualify for straight PTR because he's out on bond.
Okay.
He has an open case. We don't put those on PTR.
All right, then I'll set the bond.
We would ask for, in the alternative, an ROR, Your Honor.
I'm not inclined to do that, counselor. I'll make the bond $100 if he doesn't qualify for mental health pretrial release. But we're going to screen him for that first. So if you qualify for that, sir, you'll be released on pretrial release. So make sure you stay in touch with your attorney, okay?
Done with my attorney.
The public defender's office. So for right now, it's her, but it's her office. All right, good luck, sir. Please tell me your name.
Rakeem Lake.
Who?
Rakeem Lake.
My name is Victor Mead. I'm here on behalf of Mr. Lake.
Hold on, I don't have his case. Give me 1 second, counselor.
I'll give you more than a second.
Thank you, sir. All right, this is case number 21 CF 1875. You're here because a warrant was issued for your arrest, charging 2 counts of attempted felony murder. Counselor, is there anything you wish to be heard on?
Your Honor, we're just here to try to have a bond be set in this case. He's got long-term ties to the community. He has no history of not showing up for court.
What level felony is attempted felony murder?
He had a failure to appear in November of 2009. He's had 2 total failures to appear. And it's a life offense, Your Honor, so you'll be asking for no bond.
So I think the way the statute's written, because it's a punishable by life offense, he's not entitled to bond at first appearance, at initial appearance, but you can file a bond motion and have an Arthur hearing in front of the trial judge.
Okay.
So I'm not going to change that bond at this time. Sir, you're not allowed to have any contact with the victim's family member or any witnesses in the case. You're not allowed to possess a weapon of any kind, firearm or ammunition. So at this time, there'll be no bond, but you're still not allowed to have contact with those people even while you're in custody. Do you understand?
Yes, ma'am.
Okay. Anything else, counselor?
Well, I've got the co-defendant Shakira Wright. It's the exact same circumstances.
I'm sorry?
I've got the co-defendant that's back here also.
Okay.
So I don't know if they could get her. We got her.
All right, good luck, sir. He can go then. Ma'am, tell me your name.
Sabrina Wright.
Right.
Okay. I don't have her yet either. Give me 1 moment. Thank you. This is case number 21 CF 1931. Ma'am, you're here because a warrant was issued for your arrest for 2 counts of attempted felony murder and 2 counts of child neglect. Counselor, do you want to put your parents on the record again?
Victor Mead.
All right, so again, counts 1 and 2, there will not be any bond. Count 3 and 4, your bond is $2,500 on each. You're not allowed to have any contact with victim's family, or any witnesses in the case. You're also not allowed to have contact with the co-defendant. And I don't think I ordered that in his case, but I need to make sure.
They're married.
They can't have any contact.
Okay.
No,
So when you have the Arthur hearing and you file your bond motions downtown, you can always ask the judge to change that. But at this time, no contact. Ma'am, you're not allowed to possess a weapon of any kind, firearm or ammunition. You're not allowed to have any unsupervised contact with any minor children under 18. Do
wait.
you understand?
Wait, so I haven't been in trouble. I don't know where this coming from. I'm high risk. I have a weak immune system. I have acute bronchitis, asthma. I'm lost in this whole case.
So a
can't
warrant
get a
was issued
bond?
for your arrest for attempted felony murder. Because that charge is punishable by life, at this time, you have no bond on that. What your attorney will do, I think,
Yes.
he'll file a motion to change that bond in front of the judge who's hearing your case. He'll bring in witnesses, the state can bring in witnesses, and he'll make the case in front of that judge that the judge should give you a bond. So today, we cannot change that bond. But once he files that motion in front of the trial judge, that judge could change the bond.
And
I'll explain it to her, Your Honor.
Okay.
Thank you.
All right, good luck, ma'am. Please tell me your name.
Warren Christopher Adams, Your Honor.
In case number 21 CF 79280, a warrant was issued for your arrest for dealing in stolen property, false verification of ownership to a pawnbroker, burglary of a conveyance, and grand theft. The bond authorized on that warrant is $1,000 on count 1, $1,000 on count 2, $3,500 on count 3, and $1,000 on count 4. You're not allowed to have any contact with victims or witnesses in the case. In case number 20 CF 14302, and I'll appoint the Public Defender's Office to represent you.
Thank you, Your Honor.
A warrant was issued for your arrest for dealing in stolen property and providing false verification of ownership to a pawnbroker. Your bond is $3,000 on count 1, $1,000 on count 2. You're not allowed to return to the scene of the incident. You're not allowed to possess a weapon of any kind, firearm, or ammunition. And you're not allowed to have any contact with the victims.
Yes, Your Honor.
I'll appoint the Public Defender's Office to represent you in that case as well.
Thank you, Your Honor.
Yes, sir. Good luck.
Thank you.
Please tell me your name.
Paul Bruce.
Okay. I don't have you now. Okay, Paul Bruce.
Brown bond?
Case-
You refuse court.
Oh. All right, we'll get there in just a second. In 21 CF 2877, you're charged with possession of a controlled substance. I'm appointing the Public Defender's Office to represent you. There is probable cause. Your bond is $1,000. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. As to his out on bond case, I show he's out on bond in possession of cocaine and possession of drug paraphernalia.
Yes, Your Honor.
I'm inclined to revoke that unless there's a reason that you can give me not to.
I would just argue that they're nonviolent offenses, Your Honor. And he has he has one failure to appear from 2004.
What says the state?
Your Honor, that case is set for a status in July of 2021. At this time, the state would ask you to take no action due to being a nonviolent offense. And most of his history is also drug and alcohol-related crimes.
So you're out on bond for a drug offense and you get arrested for a new drug offense? All right, at this time, I'll take no action on that case. Good luck, sir.
And the bond was 1,000 on the new?
Yes. Oh, Sylvester Brown refused. 21 CF 2878. I'll appoint the Public Defender's Office. There is probable cause.
We'll waive, Your Honor.
His bond is $2,500. He's not allowed to return or have contact with the victim, possess a weapon of any kind, firearm, or ammunition. Please tell me your name.
I'm Takeem Camacho, ma'am.
You're here because a warrant was issued for your arrest in 21 CF 42980 for robbery armed with a firearm. I'll appoint the Public Defender's Office to represent you.
Your Honor, at this time, state's asking for no bond.
I do believe that's a punishable by life offense with
It
the
is, Your Honor.
firearm.
It is.
So at this time, there will be no bond. Your attorney will have to file a motion in front of the trial court. Sir, you're not allowed to have any contact with the victim or any witnesses in the case, even while you're in custody. Do you understand?
Can you say that again, ma'am? My apologies.
You're not allowed to have any contact with the victim or any witnesses, even while you're in custody. Do you understand that?
Yes, ma'am. I have no idea I don't know what's going on. I don't know who's the witness or the victim. I'm confused. That's why I'm trying to have
Okay,
a
hold on.
conversation.
A warrant was issued for your arrest, alleging that on or about the 9th of January, 2021, you made a verbal agreement with Mr. Stroud to purchase a car. And then that deal went, sir, you said you didn't know what was going on. I'm telling you what's happening and you're not listening.
I'm sorry.
I don't really need to do that. If you want to hear from me, I'll tell you. If you don't need to hear this, I don't need to say it.
Okay, I'm sorry.
Do you want to hear it?
Yes, ma'am.
You don't have to. You can just talk to your attorney.
No, I want to hear it.
All right. So the allegation is that the deal went bad between you and Mr. Stroud. You pulled a black gun, pointed it at his face, and demanded money. That's the probable cause. So we're not having an evidentiary hearing or a trial today. There's no bond on this. Probable cause has already been found. So talk to your attorney. Please tell me your name.
William Lewis Dotson.
In case number 21 CF 2875, you're here charged with aggravated assault with a weapon. I'm appointing the Public Defender's Office to represent you. There is probable cause. Your bond is $1,500. You're not allowed to have any contact with the victim. You're not allowed to possess a weapon of any kind, firearm, or ammunition. And you're not allowed to return to this scene. Do you understand?
Yes.
All right, good luck, sir. Please tell me your name.
Michaela Dyer.
In case number 20 CF 14301, a capias was issued for your arrest for failing to appear for arraignment for grand theft. There's $2,000 bond authorized on that capias. I'll appoint the Public Defender's Office to represent you, and I'll take no action on the out on bond case. Good luck. Please tell me your name.
Guadalupe Flores.
In case number 21 CF 2036, a warrant was issued for your arrest for failing to report, failing to maintain your sex offender reporting requirements. Your bond is $5,000. Sir, you still have to maintain all of those reporting requirements. You understand?
I understand.
I'll appoint the Public Defender's Office to represent you. Good luck. Please tell me your name.
Todd Goulet.
You're here because a warrant was issued for your arrest out of Hillsborough County, case number 222-73853, for failing to appear on a charge of false information to a pawnbroker, dealing in stolen property. There's no bond. And then in 222-72413, for failing to appear for soliciting another to commit prostitution, the bond is $500. I'll appoint the Public Defender's Office to represent you, and we'll contact them and let them know that you're here. In case number 20 CF 12110, a warrant was issued for your arrest for dealing in stolen property and providing false information, false verification of ownership to a pawnbroker. Your bond is $2,500 and $1,000. You're not allowed to have any contact with the victim, and I'll appoint the Public Defender's Office to represent you. Hold on one second. All right, good luck, sir. Can you not feel that? I have it rotating. I do. But is it hitting the wall? Just back it up so you can feel it. Back it up. Please tell me your name.
T. Gray.
In case number 21CF2852, you're here charged with possession of methamphetamine. I'll appoint the public defender's office to represent you. There is probable cause. Your bond is $1,000. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. I show that you're out on bond for possession of methamphetamine. In case number 20CF994.
Yes, Your Honor, we would just point out that he has 0 failures to appear, that my client is employed full-time at this time, and I do not see, I see a juvie arrest for a battery, but other than that, it looks as though all of his charges are non-violent offenses, his criminal history.
All right, I'm going to revoke your ROR on that case, but I'll give you a $1,000 bond in that one as well with the same conditions. You can't possess or consume illegal substances or have contact with known drug dealers. Do you understand?
Yes, ma'am.
Good luck. Please tell me your name.
Sarah Green.
In case number 0045793, a warrant was issued for your arrest out of Polk County
Yes, ma'am.
for failing to appear on a charge of possession of clonazepam, possession of cannabis, possession of drug paraphernalia, and driving while license suspended. There's no bond authorized on that warrant. I'll appoint the public defender's office to represent you, and will notify them that you're here.
Yes, ma'am.
In 19 CF 4852, a capias was issued for your arrest for failing to appear on a charge of grand theft. The bond on that is $2,500, and I'll appoint the public defender's office. Good luck.
Thank you.
Stephanie McLaughlin is in the hospital, Your Honor.
Should we reset it for tomorrow, or?
We'll waive, Your Honor.
All right, I'll appoint the public defender's office. This is case number 20 CF 1439. Oh, it's a capias for failing to appear, and there's bonds, $1,000 and $500. Thank you, Counselor. Oh. All right. Please tell me your name, sir.
Lamar Richards Jr.
In case number 19 CF 16061, a capias was issued for your arrest for failing to appear on a plea hearing for a possession of a firearm by a convicted felon. There's no bond authorized on that. I'll appoint the public defender's office to represent you. In case number 21 CF 2859, a capias was issued for your arrest for accessory after the fact to first degree or life felony. The bond authorized on that is $20,000, and I'll appoint the public defender's office to represent you in that one as well. You're not allowed to have any contact with the victim, co-defendant, or witnesses. You're not allowed to return to the scene of the offense. You're not allowed to possess a weapon of any kind, firearm, or ammunition. You can't drive without a valid driver's license. Good luck, sir.
Your Honor, what was the first case you said for him?
Oh, that was a different defendant, wasn't it? It was caught, they were stuck together.
Okay.
So the possession of firearm by a convicted felon is not your charge. I'm sorry, they were paperclipped together. They just get stuck. Thanks for catching that. Please tell me your name.
Donald Ridenpaw.
All right, you have a failure to appear. A capias was issued for your arrest for failing to appear on a charge of possession of a firearm by a convicted felon. 19 CF 16061. I'll appoint the public defender's office to represent you, and your bond is $0. Good luck. Please tell me your name.
Derek Robertson.
Case number 20 CF 6333. Capias was issued for your arrest for failing to appear for court on a possession of a controlled substance. Your bond is $2,500. I'll appoint the public defender's office to represent you. In 20 CF 5669, a capias was issued for your arrest for failing to appear for court on a charge of delivery of cocaine. Your bond on that is $10,000, and I'll appoint the Public Defender's Office to represent you. In 21 CF 2879, you're here charged with possession of a concealed firearm by a convicted felon, possession of a firearm. There is probable cause. I'll appoint the Public Defender's Office to represent you. Your bond is $5,000. You're not allowed to possess a weapon of any kind, firearm, or ammunition. Do you understand?
Ma'am, I have a quick
Yes, sir.
question for you. The reason why I have the FTA though, ma'am, because I was working.
Don't talk about the facts. Don't talk about the facts of the case.
Was working.
So
I knew about it, the other.
I can't hear you at all.
See, I was working, so I didn't know about the other court date. I never get no paper.
So I can't change another judge's capias. You need to talk to your attorney and see if your attorney will file a motion on your behalf, and maybe the judge will.
So what you do?
Change your
raise,
bond.
You raise my bond up more?
I did not raise your bond.
Because I see on the original paper here, it says 17.5, ma'am, and I can't really afford it. So that's why I'm asking you. I'm a single parent.
No, so on one of the capiases, your bond is $2,500. On another capias, your bond is $10,000. And then on the last one, your bond is $5,000.
17.5 for all of them?
You have 3 different cases, sir. You have 3 cases. So you have bond in all 3. So if you have a defense or something that you want to talk to your attorney about, that's what you need to do, is ask your attorney how to get that in front of the trial judge. Okay? All right, good luck, sir. Please tell me your name.
Ramon Robinson.
In case number 21 CF 2476, a warrant was issued for your arrest for robbery, aggravated assault, and video voyeurism. The bond authorized is $5,000 on count 1, $5,000 on count 2, $2,500 on count 3. You're not allowed to have any contact with the victim. You're not allowed to possess a weapon of any kind, firearm, or ammunition. As to case 20 CF 8018, you're out on bond for carrying a concealed weapon by a convicted felon, possession of cocaine, and resisting an officer without violence.
Your Honor, state would ask that it be revoked due to the new violent offenses.
At this time, I will revoke your bond. I don't know if I said I was appointing the public defender in the first case, but I am.
Okay, thank you, Your Honor.
All right, good luck, sir.
You're revoking the bond on?
I am.
On the first case, you said?
Carrying a concealed weapon by a convicted felon, possession of cocaine, and resisting an officer without violence. That's the one I'm revoking.
Okay, so not on the robbery and stuff?
Right, you have a bond on those.
Okay.
So talk to your attorney about filing a motion for you.
Thank you, Judge.
Yes, sir. Please tell me your name.
Grant Thomas.
In case number 21 CF 2850, you're charged with possession of fentanyl, possession of methamphetamine, possession of cocaine, and possession of drug paraphernalia. There is probable cause. Your bond is $1,000 on count 1, $150 on counts 2 and 3, and $100 on count 4. You're not allowed to possess or consume any illegal substances or have contact with any known drug dealers. I'll appoint the Public Defender's Office to represent you. As to his out on bond case, 21 CF 1833, it's possession of MDMA.
Your Honor, that arrest was February 13th, so about a month ago, and it hasn't been filed on yet. Since the case has not been filed on, the state would ask you to take no action. And both offenses are nonviolent offenses.
And what?
The original case and this new case are both nonviolent offenses.
And Your Honor, his last failure to appear was in 2000.
He did have a conviction for possession of cocaine in 2020, though.
All right, I'll not revoke your bond at this time. Good luck, sir. Please tell me your name.
Carlos Vargas.
In case number 21 CF 2867, You're charged with driving while license revoked as habitual offender and counterfeiting license plate. I'll appoint the public defender's office to represent you. There is probable cause. Your bond is $2,500 on count one, $150 on count two. Sir, you can't drive without a valid driver's license, you understand? In case number 21 CF 2868, you're charged with possession of cocaine and possession of drug paraphernalia. I'll appoint the public defender's office to represent you. There is probable cause. Your bond is $1,000 on count one, $100 on count two. You're not allowed to possess or consume illegal substances or have contact with known drug dealers. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Any action on the out on bonds?
Oh, wait.
Yes, 2 cases.
Wait, you have an out on bond case. Oh. It's possession of cocaine and petty theft, 2 prior convictions.
Your Honor, because these are nonviolent offenses, we would also ask you take no action. He is currently employed full-time.
What says the state?
The state's only concern is he had a failure to appear as recent as January of 2020. But given that he has bond in the other cases, they ask that you take no action.
It's possession of cocaine and introducing contraband into a county facility.
We only filed on the possession of cocaine, Your Honor.
All right.
And that case is currently set for PTC in May.
Sir, I'm going to revoke your bond in case number 20 CF 13382. And I'll double what you currently have as bond. As to case 20 CF 13025. I'm also going to revoke your bond and double it. Good luck, sir.
What does that mean?
It means that you still have a bond, but I revoked your current bond and then doubled the amounts. So if you're able to post those bonds, you can bond out.
Okay.
Good luck. Please tell me your name.
Susan Whitlock.
You're here because a warrant was issued for your arrest out of Polk County in case number 0070404. Wait, here it is. I know. CF 190110007 for failing to appear on a charge of possession of cocaine. The bond is $2,000. Possession of paraphernalia, the bond is $1,000. And offering to commit prostitution, the bond is $500. We'll notify them that you're here, but if you're able to post those, you can bond out. As to case number 20 CF 1120, a capias was issued for your arrest for possession of cocaine and possession of drug paraphernalia. The bond is $3,500 on count one, $500 on count two. I'll appoint the public defender's office to represent you. In case number 20 CF 2655, a capias was issued for your arrest for failing to appear for a status hearing on a charge of possession of a controlled substance. The bond is $2,500, and I'll appoint the public defender's office to represent you. Good luck, ma'am.
Also, I have a question. The
Yes.
solicitation, that was dropped last January.
It may have been, I don't know. That's in another county.
Okay, I'm sorry.
So we'll notify them you're here, but if you're able to post the bond, you can still get out. But I can't drop it. It's from another county.
Okay.
Please tell me your name.
Jimmy Ray Williams.
In case number 21 CF 2860, you're charged with petty theft with 2 prior convictions. I'm going to appoint the Public Defender's Office to represent you. There is probable cause. Your bond is $500. Sir, you're not allowed to return to Walmart. You understand?
Yes, yes, ma'am.
All right, good luck. Please tell me your name.
Lum Herman Garnett III.
You're here because a warrant was issued for your arrest in case number 19 CF 12387 for failing to live without violating any law by committing the offense of burglary of a motor vehicle conveyance in Seminole County and failing to live without violating any law by committing the criminal offense of petty theft. There's no bond authorized on this warrant. I'll appoint the Public Defender's Office to represent you. Good luck, sir. Please tell me your name.
Jonathan Hayes.
You're here because a warrant was issued for your arrest in 2013 CF 12244. The warrant says that you failed to pay the state of Florida the $20 per month for cost of supervision. You left your county of residence without first procuring the consent of your probation officer. That you failed to live without violating any law by committing the offense of battery in Seminole County. And by failing to make a good effort toward completing basic or functional literary skills or a high school equivalency diploma. There is no bond authorized on this warrant. I'll appoint the Public Defender's Office to represent you. Good luck. Please tell me your name.
Joshua Simpkins.
In case number 20 CF 14241, a warrant was issued for your arrest for armed burglary of a conveyance, grand theft of a firearm, burglary of a conveyance, 2 counts of criminal mischief, and 1 count of petty theft from a motor vehicle. The bond is $10,000 on count 1, $2,500 on count 2, $1,000 on count 3, and $100 on each of the next 3 counts. You're not allowed to return to the scene, have contact with any victims or witnesses. You're not allowed to possess weapons of any kind, firearms, or ammunition. Do you understand?
Your Honor,
Yes.
I may be incorrect. However, I do believe the count 1 is a PBL.
I wondered that same thing. It doesn't say burglary of a conveyance with a...
With an explosive or dangerous weapon, which
It says armed burglary of a conveyance. Is that punishable by life?
810
Or is that-
2. Can you give me 1 second?
Oh, it's with a firearm.
Loading or dangerous weapon, which is a firearm, Your Honor.
It is punishable by life. You're correct, Counselor. Sir, there's no bond on count 1. The other bonds will remain the same.
Yes, Your Honor. In our system, we have as the armed burglary of conveyance with a firearm. So
Yeah, it's with a firearm. Once I saw that, you're correct. All right, the next case is 19 CF 13, wait. Yeah, 19 CF 13366. It's a violation of probation. A warrant was issued for your arrest with no bond for violating your probation by owning a firearm or carrying a firearm, leaving your county of residence without first procuring the probation officer's permission, and failing to live without violating any law by committing the criminal offense of aggravated assault with a deadly weapon. In case 19 CF 15508, a warrant was issued for your arrest for violating your probation. No bond was authorized on that warrant for possessing, owning, or carrying a firearm, leaving your county of residence, and failing to live without committing any new law violations. I'll appoint the Public Defender's Office in each of your cases. Good luck, sir. Please tell me your name.
Jacob Sorsey.
He has an attorney. Can we call them? Can we do the gentleman behind him while we wait on the attorney? Please tell me your name, sir.
SOL.
In case number 21CF2874, you're charged with burglary of a dwelling, grand theft of a motor vehicle, grand theft, and criminal mischief. I'll appoint the public defender's office to represent you. There is probable cause. Your bond is $5,000 on count 1, $150 on counts 2 and 3, $100 on count 4. You're not allowed to return to the scene. You're not allowed to have any contact with the victim or any witnesses in the case. Do you understand?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. In case 17CF1368, you have no bond on violating your probation. I'll appoint the public defender's office to represent you. Good luck. What's your name?
Shakira Swint.
All right, she's got an attorney too. So I have 3 in a row that all have private attorneys. I'll give those to you. We'll have to call her back in a minute. Were you able to get the other one? Not yet. Do you have an attorney on there? Okay. He's going to have to wait. We don't have his attorney on the line. And then can you give her those two because we have 3? How about Mr. Williams? Can we do John Williams? I have 3 in a row with private attorneys who want us to call, so. Please tell me your name, sir.
John Williams.
In case number 19CF9515, a warrant was issued for your arrest for violating your probation by failing to live without violating any new laws, by committing the criminal offense of larceny, grand theft of a firearm, and carrying a concealed weapon. There is no bond authorized on that warrant. I'll appoint the public defender's office to represent you. Good luck. The first one? That's the first one. Okay, then these are the next 2 with private attorneys who want us to call. Good afternoon, this is Judge Gibson. Can you hear me?
Yes, ma'am, I can. Thank you, Your Honor.
All right, we're here with, tell me your name one more time.
Jacob Sorsey.
Case number 18CF17134. Counselor, do you want to put your appearance on the record?
Yes, Benjamin Wurtzel on behalf of Mr. Sorsey.
All right, sir, you're here today because a warrant was issued for your arrest for violating your probation by being in possession of a controlled substance, to wit, cannabis. At this time, there is no bond authorized on that warrant. Counselor, is there anything you wish to be heard on?
Your Honor, we're going to make any requests directly to the trial court.
I'm sorry, Counselor, I can't hear you at all.
Can you hear me better now?
Yes, now I can hear you.
Okay. We're going to direct any request for bail directly to the trial court.
I think that's wise.
I have filed a plea of not guilty and a waiver of arraignment. Is the clerk able to go ahead and set this for a violation of probation status hearing in the trial division?
No. We can't do that. What will it be set for? Judge Lattimore? It'll be set for a VOP date with Judge Lattimore.
Okay, the arraignment that's set on the 15th for Monday is going to remain set for the time being?
Yes.
Okay. All right, I have nothing further this time, Judge.
All right, and you can always contact Judge Lattimore if you want to change that. I don't know if she will, but that's who would be able to change that date.
Okay, thank you.
All right, thank you, Counselor. Good luck, sir. Okay, who's next?
Teleria?
He's got an attorney. She's working on that. Got the one before it. We have Swint next. Good afternoon, this is Judge Gibson. Can you hear me?
Yes, Your Honor. Good afternoon. Not here.
I can't hear you.
I'm sorry, Your Honor. Can you? Is this better, ma'am?
No.
I don't know why we're getting that echo.
All right, ma'am, tell me your name.
Takira Swint.
In case number 19 CF 365680, you're here because a warrant was issued for your arrest for violating your probation. Counselor, would you like to put your appearance on the record?
Yes, Your Honor. Jim Gelati from Ms. Swint.
The warrant says that you failed to remain in a specified place after being instructed not to leave the county of your residence without first procuring the consent of your probation officer, by failing to live without violating any law, by committing the criminal offense of driving under the influence, and by using intoxicants to excess. There is no bond authorized on this warrant at this time. Counselor, is there anything else you wish to be heard on?
Your Honor, I was just going to make a request for the court to consider bond, but I understand you may feel you're powerless to do that at this time.
I think I can change it, but I'm not inclined to.
And the only reason I was asking, ma'am, is that my understanding is the new law violation has already been referred to pretrial diversion, so I was assuming the state was aware of it prior to making the recommendation to CTG.
Even if that's correct, Counselor, I'm not inclined to grant bond at this time. I think you should address that with
understand,
Judge
Your
Laurent.
I'd be happy to do that. Thanks.
Thank you. Good luck, ma'am.
Have a good day.
You as well. All right, next, Teleria.
Teleria?
Just a moment, we're trying to get your attorney on the line. This is Judge Gibson. Can you hear me?
Hi, Judge Gibson. This is Matt Clark. I can hear you.
I'm having a really hard time hearing you.
Can you hear me better now?
Yes.
Okay, I'm sorry. I had you on speaker for one moment.
All right, we're here with Dylan Teleria.
Yes, Your Honor.
Counsel, if you want to put your appearance on the record.
Yes, Matthews Bark on behalf of Mr. Telleria.
In case number 21 CF 1331, you're here, sir, because a warrant was issued for your arrest for burglary of a dwelling and grand theft. The bond authorized on that warrant is $10,000 on count 1, $1,000 on count 2. You're not allowed to have any contact with the alleged victim. You're not allowed to return to the scene. We need you to confirm your residential address prior to being released.
15267 Perdido Drive, Orlando, Florida, 32828.
You're also not allowed to possess a weapon of any kind, firearm, or ammunition. In case number 17 CF 2437, a warrant was issued for your arrest for violating your probation by failing to make restitution payments and failing to successfully complete 96 hours of community service. There is no bond authorized on that at this time. Counsel, are you representing him on both cases?
No, Your Honor, I didn't know about, is that an Orange County new law violation?
Did you say, is that an Orange County violation?
Yes, if it was a new law, Orange County new law violation.
Okay.
Are you?
I was not aware of that.
He was also on probation in the Ninth Circuit.
Yes, I understand that part.
Okay. Yes, both are the
He was on
circuit.
probation, and then he's got a new Orange County law violation.
Yes.
Okay.
All right.
I'm only referencing him on a violation of probation thus far.
All right, sir. You have a new law case. Do you want me to appoint the public defender's office to represent you?
Yeah, I didn't know I knew one, but I think he's gonna represent me, last I heard, but,
So he hasn't filed an appearance in that case.
okay.
So at this time, he doesn't represent you. Do you want me to appoint the public defender, or do you want to hire him?
Let me get a PD, please.
All right, I'll appoint the public defender's office. Thank you, counselor. Good luck, sir.
Thank you, Your Honor. Have a good day.
You as well. Please tell me your name.
Titan Robichaud.
You're here because of, I'm sorry? Oh, okay, thank you. Sir, you're here because a warrant was issued for your arrest out of Brevard County for failing to appear for arraignment on a charge of driving while license suspended. Hold on one second. I think the bond on that is $500. All right, so you have a bond, sir. But we'll also notify them that you're here, so if they want to come and get you, if you don't bond out, they'll come and get you, okay?
Is there any way I can get an ROR? Because they had all my paperwork wrong. All my paperwork over there was wrong. I went there.
I can't do that because this is from another county. So the judge in the other county has to fix that. But if you post the bond, you can get out. I'll appoint the public defender's office to represent you. Good luck. Please tell me your name.
Patrick Spencer.
In case number 69967, a warrant was issued for your arrest out of Polk County for carrying a concealed firearm. Bond is $1,000. Discharge a firearm in public, the bond is $500. Improper exhibition of a firearm, the bond is $500. CF 21001197 is your case number. We'll notify them that you're here, but you have a bond. If you're able to post it, you can get out. As to case 20 CF 11842, you're out on bond for shooting or throwing a missile into a dwelling or a structure or a vehicle. I don't know, because I don't know the offense date in the out-of-county warrant, I'm going to take no action on the out-on-bond case. Good luck, sir.
Dudley?
Oh, yes, okay. Hold on one second. I just need to know what I need. All right. Please tell me your name, sir.
Harvey Michael Dudley.
All right, so you're actually out on bond, sir, in case number 20 CF 13837 on a charge of battery on a law enforcement officer, resisting an officer with violence, and criminal mischief.
Thank you, Your Honor.
No, I'm saying you are out on, well, you were released on your own recognizance on that charge. I'm going to appoint the public defender's office if you weren't previously appointed.
We brought him back?
Ms. George?
Yeah. Mm-hmm. He told us to bring it back.
Oh,
Yeah.
I don't have a sheet, Your Honor. I was trying to find it.
Your Honor, I thought the PD appointed the 1,000 on count 1, 150 on count 2, and 100 on count 3 was this case? Was it the other one? That has almost.
All right, so the paperwork was incorrect. I had an arrest affidavit for aggravated assault.
The deadly weapon, criminal.
No, I had the Bat Leo. That's already been done. Oh, that's it. I'm supposed to be doing this one. The charge is aggravated assault with a deadly weapon, criminal mischief, and resisting without violence.
Yes.
That's what I was missing before. Sorry, I thought you gave me the other wrong PC again. And I was like, I don't need to read that.
It's John Doe.
No, it's the one I read. Okay.
It was John Doe and felony.
This is case number 21 CF 2847.
Yes.
It's all been done?
That's been done yesterday.
Oh.
He's here for that, for the fact. See if you want to take any action on that.
Ms. George, can I get the attorney to approach? Just a minute.
Nice time.
So, this happened yesterday, and those are the bonds? Or were the bonds different? Because I wasn't here yesterday.
You want to know the bonds on the aggravated assault charge?
Yes.
They were 3,500, 100, and 100. So I'm guessing the reason why they didn't catch this fad before is because he came in under John Doe. He was IA'd under John Doe. He never came to court, so they didn't know Harvey Dudley. So once they fingerprinted him is when they got the fad on him.
Your Honor, I'd like to reply to that. That ID comes from Panama City. I told the police that I was John Doe and Tallahassee. I told them I was John Doe. I was coming home from cooking.
So, Your Honor, a review of my notes does show that the client does have mental health issues and psychotic episodes.
No, I was coming home from cooking, Your Honor, and the police just asked me if I had anything sharp on me or a gun.
In the 20 CF 1383780 is what I'm reading, and they're gonna have. It looks like they're gonna have him evaluated for incompetency.
Yeah, she's doing this. She's doing this, Your Honor. The police I get along with. I've been stopped many times in the state of Florida. I cook for a living is what I do. And the lady is approaching me almost every night with their kids after I come home from cooking, particularly from McDonald's, from other places, from Tallahassee up to here. So I just use an alias name to.
It looks like he has some treatment in Lakeside, Your Honor, from what I'm reading.
Well, yeah. Somebody went in my bag and they stabbed me, and I just got out of the hospital. They stabbed me in the throat with my own knife at 7-Eleven. So.
Okay. Counselor, do you have a suggestion as to the out on bond case, the battery on a law enforcement officer resisting an officer with violence and criminal mischief?
We would ask that you take no action due to the mental health issues and the fact that we believe he may be incompetent, Your Honor.
And he wouldn't qualify for mental health pretrial release, right?
You can have him screened, but
All right, I'll have him screened for mental health pretrial release. Otherwise, I'll take no action on the out on bond cases. Good luck, sir.
Thank you, Your Honor.
Yes, sir.
So the bonds are stayed in the John Doe case?
Yes.
Okay. And is he also being screened in that one?
No.
Sorry.
All right. Are you ready for 33-day motions?
Yes, Your Honor.
Brian Presley, 21 MM 457.
Notice and on filing?
Jonathan Gombo, 21 MM 499.
It was filed yesterday, Your Honor.
Andrew Smith, 21 CF 1513.
Notice and on filing?
Johnny Ross, 20 CF 14489.
Notice and on filing?
Does anyone else have any other business before the court adjourns? Yes, ma'am.
Yes, ma'am. I'm sorry. For the Patricia, give me one moment. Patricia Corica, she was seen earlier for a domestic violence case. You gave her PTR. At the time of her interview, she came in, she didn't give us an alternate address, but due to that she can't have any contact with the victim, maintain separate residence, she gave us an alternate address that's out of Indiana. So they wanted to know, would you allow her to go to Indiana?
Yes.
Okay.
The only case, I don't know if,
On the court order.
sorry.
What?
We need that to be placed on the court order, that she's allowed to go to Indiana. Thank you very much.
The only thing I don't know if was called is Miss Blake. She was in traffic. It was a DUI with property damage.
She may have bonded. I don't have that one.
I know we had another Blake, but is this Talia Blake?
She bonded.
All right, thank you.
All right, anything further?
No, Your Honor.
Court will be adjourned.